Declaration is not unimportant, it simply has no authority in constitutional law. While the Declaration is not antithetical to the Constitution, they argue that it has little practical value in deciding important cases that wind up in the Supreme Court.
Now let's explore the other side.
Those who view the two documents as inseparable make strong claims worth exploring. First, they point out that the country did not begin in 1787. Rather, the nation grew from a collection of seedling colonies through a series of evolutionary stages, the most critical stage of the nation's existence being the Declaration of Independence. It expressed the revolutionary self-evident principle that all men are created equal and that all people, regardless of race, class, or any other secondary characteristic, have basic rights that cannot be taken away. The Constitution enjoys its authority today because of the existence of the Declaration, and the Declaration only. With this in mind, the American government obtains its power to make decisions and protect rights from the people only on the foundational principle of consent. The Constitution is amendable because of the argument stated in the Declaration that no government is absolute. If the government does not protect the rights of the people have a right to alter or abolish the government.
Constitutional scholar Randy Barnett phrases it succinctly. The U.S. Constitution is best understood as the means to the ends of the political theory found in the 1776 Declaration of Independence. The Declaration is primary because it correctly identifies the political theory on which the United States was founded.
Yet another group of scholars find a compromise between the two views. Neither document, they argue, is primary. Instead, they are mutually reinforcing.
In the words of Dr. William B. Allen, they are necessary and reciprocal supports.
This perspective, which is sometimes called the fusionist view, can be traced back to the abolitionist movement in the 1840s and 50s. One of the most important defenders of this view was the African-American abolitionist, orator, and social reformer Frederick Douglass. In one of his greatest speeches, The Meaning of the 4th of July, Douglass said that the Declaration was the ring bolt to the chain of the nation's destiny. The principles of the Declaration were saving principles and the only guidance through the approaching conflict. In an unforgettable passage, Douglass enjoined his audience to cling to the principles of 1776 like a storm-tossed mariner. Abraham Lincoln agreed with Douglass and would become the most famous exponent of the idea that the two documents are mutually reinforcing reciprocal supports. During the Gettysburg Address, Lincoln defended his long-standing view that the Union is much older than the Constitution. To illustrate, have you ever wondered why Lincoln marked the occasion with the phrase 7 years ago?
A score is equal to 20 years, and so when Lincoln says that 7 years ago, our fathers brought forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal, Lincoln is referencing a point 87 years in the past.
The Gettysburg Address was delivered on November 19, 1863. 1863 minus 87 is 1776, the year of the signing of the Declaration of Independence. By tracing nationhood to the Declaration, Lincoln was aiming at two intertwined goals. First was his intent to weaken the South's justification for secession. Second was his moral argument that reached to the heart of the meaning of the American founding. By tracing nationhood back to 1776, Lincoln strengthened the majority view that the U.S. Constitution was fundamentally at odds with slavery. While both Lincoln and Frederick Douglass acknowledged that slavery had been contemplated in the political act of writing a constitution, both men disagreed with those, like William Lloyd Garrison, that the U.S. Constitution was a pro-slavery instrument. In Garrison's words, a covenant with death and an agreement with hell.
Countering that view, both Lincoln and Frederick Douglass pointed out that a historically informed view of the U.S. Constitution would take into account both the ways in which the Constitution had failed to live up to the ideals of 1776 and in the ways which it had succeeded. In Douglass's words, if the South has made the Constitution bend to the purposes of slavery, let the North now make that instrument bend to the cause of freedom and justice.
As we approach the 4th of July this year, and in the spirit of the abolitionist Frederick Douglass, perhaps we can learn to think more about the ways in which the Declaration of Independence and the U.S. Constitution inform and support each other, often in surprising but important ways.
What do you think? Which of these positions is most persuasive to you? Let us know what you think in the comments below.
Before we end, we want to answer one of our most frequently asked questions. Every few years, an old draft or copy of the first official printing of the Declaration seems to pop up somewhere. In 2018, a Declaration broadside was found and sold at auction for $1.2 million. Are there still copies floating around, and could a copy be in your grandparents' attic? The answer is yes. And to find out, we recommend giving Grandma or Grandpa a call to say hi and to see if you can help give it a clean. With that recommendation out of the way, thanks for watching. And if you are interested in finding out more, take a look at our curated reading list in the description. We wish you a happy 4th of July.
The 19th Amendment to the United States Constitution was ratified on August 26, 1920, and it states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. This was a groundbreaking amendment to the Constitution because it granted women the right to vote in all elections. The road to ratification was a long one. The debate surrounding what would eventually become the 19th Amendment spanned 41 years in Congress. Closely connected to the 19th Amendment is the Edmunds-Tucker Act. This was an act of Congress that initially set out to restrict the practice of polygamy in the United States, but also took away women's right to vote in the Utah Territory. This is very significant because women in Utah had had the right to vote for 17 years prior to the passage of the Edmunds-Tucker Act in 1887. A team of student researchers at Utah Valley University has modeled the Edmunds-Tucker Act and portions of the 19th Amendment. Because the ratification process of the 19th Amendment spanned 41 years, the portions we have modeled include everything from the first proposal to the first vote, as well as the final proposal of the amendment.
Working here at the center with something like Quill, I'm conducting research, and the directors are here to help guide us and to help us navigate things as we go along, but it's really student-led in that we are doing research and we are having to think like graduate students while still being undergraduate students. So I think it's just, I imagine what I've been doing for the last 2 years here at the center is essentially what I would be doing for the first 2 years of a graduate program. So I think it's been just unbelievably helpful in that respect.
So the center has helped me expand the belief of what I'm capable of. Where I first thought it had to be linear and rigid and all I need to do is graduate, the center has helped me expand my belief in what it means to be an undergraduate student. I can be doing research and completing essays and working with professors in a mentorship position more than just a consultant or just an educator. These people are really interested in my future and what I want to bring to eventually all of our futures. I believe the people here in the center believe we're capable of change. So when I talk to them and they're talking to me about what career paths are available or what opportunities are here in the center, they mean it. They're talking to you sincerely and they really do want to see the center make a difference in your life so that you can go on and make differences in the future. And that is something that really opened my mind to the possibilities of what is available to me, and that has been a critical part of being in the center.
My biggest motivator for applying to the center was I felt like I was working on political science, and then when I left school I was doing whatever job to kind of make ends meet. And it's really like a situation where you've got one foot in your education and in the field that you want to study, and then you have another foot that's wherever the wind blows, kind of like I'm just getting by, getting myself through college. And for me, working at the center was a way to get both of my feet into political science and constitutional studies, so I can really just immerse myself in it. And it becomes not only my education in what I'm doing in parts of my free time, but also a means to make money, which has been great. It's allowed me to really excel, I think, and gain an edge in my studies.
One of the great things with the center is always paying attention, not just what you're doing now, but what's next. And a lot of the administrators here provide great mentorship opportunities to us as students. So I've been able to get a better grasp of what can I be expected to be doing in my first year of law school, and keeping that mindset when doing my work here at the center. So understanding that in my first year of law school, I'm going to be doing a lot of research into case law and legislative intent behind some very famous decisions. But being able to understand how to conduct that research, especially within Quill itself, because of the center, I think has helped me just better prepare and have a lot more confidence, knowing that I have a head start in doing the amount of research and the amount of reading that will be expected from me in my first year of law school. So what I would tell any freshman or sophomore in the program with aspirations for law school, I would let them know to take full advantage of the opportunities available here at the center, because the networking opportunities, the relationships you build here, and just the competency that you're going to gain in writing and conducting research is unparalleled at any college institution. Quite frankly, a lot of the research we're doing is comparable to that of any postgraduate institution. So I would tell any freshman or sophomore, if they want to stand out in the application process, whatever their goals after their undergraduate degree is, the Constitutional Studies Center is the absolute best place to be in the best position possible to fully take advantage of any opportunity that they want to seek out.
So I got involved with the center back in August of 2019. What I've been impressed with from day one is the Institute recognizes its contribution to academics, its contribution to you as students, as you view, but they also recognize they've got a blind spot, and it's teaching. With Rod and Andy and Scott, from day one, they're like, we are experts in this, but we don't know what classroom teachers need. What do you need? And that has been so refreshing to work with the university. And not all universities approach high school with questions. Instead, they come more with mandates and saying, this is what we're going to do because this is the need we see, which is a good approach because they do have an expertise about what they need. But what I appreciate about the center is they came and said, this is what we want. What do you need? And that approach has been the best partnership with high schools I've ever worked with.
The Declaration of Independence is only 1,458 words. It can be read aloud in just a few minutes, but its meaning is not always clear. Its history is often debated, and its central claim that all men are created equal is still a subject of ongoing controversy. This year, as we get ready for a unique moment in our long and explosion-filled history of celebrating Independence Day, we are going to do something a little different. Instead of focusing on the familiar words of the Declaration itself, we're going to dig a little deeper into the question of the relationship between the Declaration and the U.S. Constitution. Stay with us as we look at this question, which may give us a new take on the meaning of the 4th of July. So, should these documents be read together, or do they serve different purposes?
This is a surprisingly difficult question to answer, even though the physical documents are usually kept close together, never to be separated like twins or the 4th of July and cheeseburgers.
the physical documents are practically inseparable. In August 1814, the Declaration and Constitution were saved from destruction by State Department clerks who moved them to the basement of a Georgian brick house in Leesburg, Virginia. During World War II, the two documents were rushed onto a Pullman car and accompanied by heavily armed government agents and shipped to Fort Knox for safekeeping. Since 1952, the two documents have made their home in the National Archives, protected by the most advanced security systems in the world. While physically the documents seem inseparable and written only 11 years apart, does that mean they serve the same purpose?
Several scholars say no.
Some scholars argue that they serve different purposes, and some even argue that the Constitution was written to undo some of the more idealistic principles of the Revolutionary Declaration.
Is the Constitution a fulfillment of the ideals of the Declaration? Or does the Constitution undo those ideals by placing checks on liberty and compromising with slavery? Let's start with the first view, that the Constitution and Declaration are at odds with each other.
Anti-Federalists, those who opposed the adoption of the Constitution, were the first to make this case. In 1787, as the Constitution was being debated, many anti-Federalists believed that the Constitution was a dangerous turn away from their vision of a new nation as an aggregation of free and independent states. A few even worried that the new Constitution, which favored a large republic and a stronger central government, would threaten the rights-based limited government vision of the Declaration. According to this view, the Declaration was a statement of small and limited government. For the rights of life, liberty, and the pursuit of happiness to be secure, the government had to be close to the people and limited in size and power. In their view, the Constitution was a dangerous deviation from these principles. There are a number of variants of what is sometimes called the rejectionist position. In the 1860s, Southern leaders, including Alexander Stephens, argued that the Declaration was being used to undermine the Union. Stephens once argued in his notorious and widely condemned Cornerstone speech, the Declaration of Independence was erroneous. The foundation of the new government in the South was based on the principle that all men are not equal. Stephens insisted a new peace could only be secured if we abandoned the Declaration as a founding document and as a guide for a revised post-war constitution. This was not an uncommon view in the South during the Civil War era. Abraham Lincoln's political rival, Stephen A. Douglas, argued that popular sovereignty, not human equality, was the most important guiding principle in the Declaration of Independence. John C. Calhoun argued that the idea of universal human equality began and ended in the Garden of Eden with Adam and Eve. Everyone else is born into various modes of superiority and subjugation. Therefore, the Declaration of Independence could only be viewed as a mistake. Calhoun called it a poisonous fruit that would result in the destruction of the Union.
The rejectionist view is accepted by some scholars today, but for quite different reasons.
Some follow the progressive historian Charles Beard, who argued that the Constitution itself is flawed. For Beard and historians who follow in his footsteps, the framers of the U.S. Constitution had betrayed the principles of the Declaration of Independence. The 1787 founding is to be viewed as an oligarchic coup, which toppled the mighty ideals of equality at the heart of our most important national document. Finally, a large and influential group of legal scholars and historians argue that, while the Declaration is not unimportant, it simply has no authority in constitutional law. While the Declaration is not antithetical to the Constitution, they argue that it has little practical value in deciding important cases that wind up in the Supreme Court.
Now let's explore the other side.
Those who view the two documents as inseparable make strong claims worth exploring. First, they point out that the country did not begin in 1787. Rather, the nation grew from a collection of seedling colonies through a series of evolutionary stages, the most critical stage of the nation's existence being the Declaration of Independence. It expressed the revolutionary self-evident principle that all men are created equal and that all people, regardless of race, class, or any other secondary characteristic, have basic rights that cannot be taken away. The Constitution enjoys its authority today because of the existence of the Declaration, and the Declaration only. With this in mind, the American government obtains its power to make decisions and protect rights from the people only on the foundational principle of consent. The Constitution is amendable because of the argument stated in the Declaration that no government is absolute. If the government does not protect the rights of the people have a right to alter or abolish the government.
Constitutional scholar Randy Barnett phrases it succinctly. The U.S. Constitution is best understood as the means to the ends of the political theory found in the 1776 Declaration of Independence. The Declaration is primary because it correctly identifies the political theory on which the United States was founded.
Yet another group of scholars find a compromise between the two views. Neither document, they argue, is primary. Instead, they are mutually reinforcing.
In the words of Dr. William B. Allen, they are necessary and reciprocal supports.
This perspective, which is sometimes called the fusionist view, can be traced back to the abolitionist movement in the 1840s and 50s. One of the most important defenders of this view was the African-American abolitionist, orator, and social reformer Frederick Douglass. In one of his greatest speeches, The Meaning of the 4th of July, Douglass said that the Declaration was the ring bolt to the chain of the nation's destiny. The principles of the Declaration were saving principles and the only guidance through the approaching conflict. In an unforgettable passage, Douglass enjoined his audience to cling to the principles of 1776 like a storm-tossed mariner. Abraham Lincoln agreed with Douglass and would become the most famous exponent of the idea that the two documents are mutually reinforcing reciprocal supports. During the Gettysburg Address, Lincoln defended his long-standing view that the Union is much older than the Constitution. To illustrate, have you ever wondered why Lincoln marked the occasion with the phrase 7 years ago?
A score is equal to 20 years, and so when Lincoln says that 7 years ago, our fathers brought forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal, Lincoln is referencing a point 87 years in the past.
The Gettysburg Address was delivered on November 19, 1863. 1863 minus 87 is 1776, the year of the signing of the Declaration of Independence. By tracing nationhood to the Declaration, Lincoln was aiming at two intertwined goals. First was his intent to weaken the South's justification for secession. Second was his moral argument that reached to the heart of the meaning of the American founding. By tracing nationhood back to 1776, Lincoln strengthened the majority view that the U.S. Constitution was fundamentally at odds with slavery. While both Lincoln and Frederick Douglass acknowledged that slavery had been contemplated in the political act of writing a constitution, both men disagreed with those, like William Lloyd Garrison, that the U.S. Constitution was a pro-slavery instrument. In Garrison's words, a covenant with death and an agreement with hell.
Countering that view, both Lincoln and Frederick Douglass pointed out that a historically informed view of the U.S. Constitution would take into account both the ways in which the Constitution had failed to live up to the ideals of 1776 and in the ways which it had succeeded. In Douglass's words, if the South has made the Constitution bend to the purposes of slavery, let the North now make that instrument bend to the cause of freedom and justice.
As we approach the 4th of July this year, and in the spirit of the abolitionist Frederick Douglass, perhaps we can learn to think more about the ways in which the Declaration of Independence and the U.S. Constitution inform and support each other, often in surprising but important ways.
What do you think? Which of these positions is most persuasive to you? Let us know what you think in the comments below.
Before we end, we want to answer one of our most frequently asked questions. Every few years, an old draft or copy of the first official printing of the Declaration seems to pop up somewhere. In 2018, a Declaration broadside was found and sold at auction for $1.2 million. Are there still copies floating around, and could a copy be in your grandparents' attic? The answer is yes. And to find out, we recommend giving Grandma or Grandpa a call to say hi and to see if you can help give it a clean. With that recommendation out of the way, thanks for watching. And if you are interested in finding out more, take a look at our curated reading list in the description. We wish you a happy 4th of July.
The 19th Amendment to the United States Constitution was ratified on August 26, 1920, and it states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. This was a groundbreaking amendment to the Constitution because it granted women the right to vote in all elections. The road to ratification was a long one. The debate surrounding what would eventually become the 19th Amendment spanned 41 years in Congress. Closely connected to the 19th Amendment is the Edmunds-Tucker Act. This was an act of Congress that initially set out to restrict the practice of polygamy in the United States, but also took away women's right to vote in the Utah Territory. This is very significant because women in Utah had had the right to vote for 17 years prior to the passage of the Edmunds-Tucker Act in 1887. A team of student researchers at Utah Valley University has modeled the Edmunds-Tucker Act and portions of the 19th Amendment. Because the ratification process of the 19th Amendment spanned 41 years, the portions we have modeled include everything from the first proposal to the first vote, as well as the final proposal of the amendment.
Working here at the center with something like Quill, I'm conducting research, and the directors are here to help guide us and to help us navigate things as we go along, but it's really student-led in that we are doing research and we are having to think like graduate students while still being undergraduate students. So I think it's just, I imagine what I've been doing for the last 2 years here at the center is essentially what I would be doing for the first 2 years of a graduate program. So I think it's been just unbelievably helpful in that respect.
So the center has helped me expand the belief of what I'm capable of. Where I first thought it had to be linear and rigid and all I need to do is graduate, the center has helped me expand my belief in what it means to be an undergraduate student. I can be doing research and completing essays and working with professors in a mentorship position more than just a consultant or just an educator. These people are really interested in my future and what I want to bring to eventually all of our futures. I believe the people here in the center believe we're capable of change. So when I talk to them and they're talking to me about what career paths are available or what opportunities are here in the center, they mean it. They're talking to you sincerely and they really do want to see the center make a difference in your life so that you can go on and make differences in the future. And that is something that really opened my mind to the possibilities of what is available to me, and that has been a critical part of being in the center.
My biggest motivator for applying to the center was I felt like I was working on political science, and then when I left school I was doing whatever job to kind of make ends meet. And it's really like a situation where you've got one foot in your education and in the field that you want to study, and then you have another foot that's wherever the wind blows, kind of like I'm just getting by, getting myself through college. And for me, working at the center was a way to get both of my feet into political science and constitutional studies, so I can really just immerse myself in it. And it becomes not only my education and what I'm doing in parts of my free time, but also a means to make money, which has been great. It's allowed me to really excel, I think, and gain an edge in my studies.
One of the great things with the center is always paying attention, not just what you're doing now, but what's next. And a lot of the administrators here provide great mentorship opportunities to us as students. So I've been able to get a better grasp of what can I be expected to be doing in my first year of law school, and keeping that mindset when doing my work here at the center. So understanding that in my first year of law school, I'm going to be doing a lot of research into case law and legislative intent behind some very famous decisions. But being able to understand how to conduct that research, especially within Quill itself, because of the center, I think has helped me just better prepare and have a lot more confidence, knowing that I have a head start in doing the amount of research and the amount of reading that will be expected from me in my first year of law school. So what I would tell any freshman or sophomore in the program with aspirations for law school, I would let them know to take full advantage of the opportunities available here at the center, because the networking opportunities, the relationships you build here, and just the competency that you're going to gain in writing and conducting research is unparalleled at any college institution. Quite frankly, a lot of the research we're doing is comparable to that of any postgraduate institution. So I would tell any freshman or sophomore, if they want to stand out in the application process, whatever their goals after their undergraduate degree is, the Constitutional Studies Center is the absolute best place to be in the best position possible to fully take advantage of any opportunity that they want to seek out.
So I got involved with the center back in August of 2019. What I've been impressed with from day one is the Institute recognizes its contribution to academics, its contribution to you as students, as you view, but they also recognize they've got a blind spot, and it's teaching. With Rod and Andy and Scott, from day one, they're like, we are experts in this, but we don't know what classroom teachers need. What do you need? And that has been so refreshing to work with the university. And not all universities approach high school with questions. Instead, they come more with mandates and saying, this is what we're going to do because this is the need we see, which is a good approach because they do have an expertise about what they need. But what I appreciate about the center is they came and said, this is what we want. What do you need? And that approach has been the best partnership with high schools I've ever worked with.
The Declaration of Independence is only 1,458 words. It can be read aloud in just a few minutes, but its meaning is not always clear. Its history is often debated, and its central claim that all men are created equal is still a subject of ongoing controversy. This year, as we get ready for a unique moment in our long and explosion-filled history of celebrating Independence Day, we are going to do something a little different. Instead of focusing on the familiar words of the Declaration itself, we're going to dig a little deeper into the question of the relationship between the Declaration and the U.S. Constitution. Stay with us as we look at this question, which may give us a new take on the meaning of the 4th of July. So, should these documents be read together, or do they serve different purposes?
This is a surprisingly difficult question to answer, even though the physical documents are usually kept close together, never to be separated like twins or the 4th of July and cheeseburgers.
The physical documents are practically inseparable. In August 1814, the Declaration and Constitution were saved from destruction by State Department clerks who moved them to the basement of a Georgian brick house in Leesburg, Virginia. During World War II, the two documents were rushed onto a Pullman car and accompanied by heavily armed government agents and shipped to Fort Knox for safekeeping. Since 1952, the two documents have made their home in the National Archives, protected by the most advanced security systems in the world. While physically the documents seem inseparable and written only 11 years apart, does that mean they serve the same purpose?
Several scholars say no.
Some scholars argue that they serve different purposes, and some even argue that the Constitution was written to undo some of the more idealistic principles of the Revolutionary Declaration.
Is the Constitution a fulfillment of the ideals of the Declaration? Or does the Constitution undo those ideals by placing checks on liberty and compromising with slavery? Let's start with the first view, that the Constitution and Declaration are at odds with each other.
Anti-Federalists, those who opposed the adoption of the Constitution, were the first to make this case. In 1787, as the Constitution was being debated, many anti-Federalists believed that the Constitution was a dangerous turn away from their vision of a new nation as an aggregation of free and independent states. A few even worried that the new Constitution, which favored a large republic and a stronger central government, would threaten the rights-based limited government vision of the Declaration. According to this view, the Declaration was a statement of small and limited government. For the rights of life, liberty, and the pursuit of happiness to be secure, the government had to be close to the people and limited in size and power. In their view, the Constitution was a dangerous deviation from these principles. There are a number of variants of what is sometimes called the rejectionist position. In the 1860s, Southern leaders, including Alexander Stephens, argued that the Declaration was being used to undermine the Union. Stephens once argued in his notorious and widely condemned Cornerstone speech, the Declaration of Independence was erroneous. The foundation of the new government in the South was based on the principle that all men are not equal. Stephens insisted a new peace could only be secured if we abandoned the Declaration as a founding document and as a guide for a revised post-war constitution. This was not an uncommon view in the South during the Civil War era. Abraham Lincoln's political rival, Stephen A. Douglas, argued that popular sovereignty, not human equality, was the most important guiding principle in the Declaration of Independence. John C. Calhoun argued that the idea of universal human equality began and ended in the Garden of Eden with Adam and Eve. Everyone else is born into various modes of superiority and subjugation. Therefore, the Declaration of Independence could only be viewed as a mistake. Calhoun called it a poisonous fruit that would result in the destruction of the Union.
The rejectionist view is accepted by some scholars today, but for quite different reasons.
Some follow the progressive historian Charles Beard, who argued that the Constitution itself is flawed. For Beard and historians who follow in his footsteps, the framers of the U.S. Constitution had betrayed the principles of the Declaration of Independence. The 1787 founding is to be viewed as an oligarchic coup, which toppled the mighty ideals of equality at the heart of our most important national document. Finally, a large and influential group of legal scholars and historians argue that, while the Declaration is not unimportant, it simply has no authority in constitutional law. While the Declaration is not antithetical to the Constitution, they argue that it has little practical value in deciding important cases that wind up in the Supreme Court.
Now let's explore the other side.
Those who view the two documents as inseparable make strong claims worth exploring. First, they point out that the country did not begin in 1787. Rather, the nation grew from a collection of seedling colonies through a series of evolutionary stages, the most critical stage of the nation's existence being the Declaration of Independence. It expressed the revolutionary self-evident principle that all men are created equal and that all people, regardless of race, class, or any other secondary characteristic, have basic rights that cannot be taken away. The Constitution enjoys its authority today because of the existence of the Declaration, and the Declaration only. With this in mind, the American government obtains its power to make decisions and protect rights from the people only on the foundational principle of consent. The Constitution is amendable because of the argument stated in the Declaration that no government is absolute. If the government does not protect the rights of the people have a right to alter or abolish the government.
Constitutional scholar Randy Barnett phrases it succinctly. The U.S. Constitution is best understood as the means to the ends of the political theory found in the 1776 Declaration of Independence. The Declaration is primary because it correctly identifies the political theory on which the United States was founded.
Yet another group of scholars find a compromise between the two views. Neither document, they argue, is primary. Instead, they are mutually reinforcing.
In the words of Dr. William B. Allen, they are necessary and reciprocal supports.
This perspective, which is sometimes called the fusionist view, can be traced back to the abolitionist movement in the 1840s and 50s. One of the most important defenders of this view was the African-American abolitionist, orator, and social reformer Frederick Douglass. In one of his greatest speeches, The Meaning of the 4th of July, Douglass said that the Declaration was the ring bolt to the chain of the nation's destiny. The principles of the Declaration were saving principles and the only guidance through the approaching conflict. In an unforgettable passage, Douglass enjoined his audience to cling to the principles of 1776 like a storm-tossed mariner. Abraham Lincoln agreed with Douglass and would become the most famous exponent of the idea that the two documents are mutually reinforcing reciprocal supports. During the Gettysburg Address, Lincoln defended his long-standing view that the Union is much older than the Constitution. To illustrate, have you ever wondered why Lincoln marked the occasion with the phrase 7 years ago?
A score is equal to 20 years, and so when Lincoln says that 7 years ago, our fathers brought forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal, Lincoln is referencing a point 87 years in the past.
The Gettysburg Address was delivered on November 19, 1863. 1863 minus 87 is 1776, the year of the signing of the Declaration of Independence. By tracing nationhood to the Declaration, Lincoln was aiming at two intertwined goals. First was his intent to weaken the South's justification for secession. Second was his moral argument that reached to the heart of the meaning of the American founding. By tracing nationhood back to 1776, Lincoln strengthened the majority view that the U.S. Constitution was fundamentally at odds with slavery. While both Lincoln and Frederick Douglass acknowledged that slavery had been contemplated in the political act of writing a constitution, both men disagreed with those, like William Lloyd Garrison, that the U.S. Constitution was a pro-slavery instrument. In Garrison's words, a covenant with death and an agreement with hell.
Countering that view, both Lincoln and Frederick Douglass pointed out that a historically informed view of the U.S. Constitution would take into account both the ways in which the Constitution had failed to live up to the ideals of 1776 and in the ways which it had succeeded. In Douglass's words, if the South has made the Constitution bend to the purposes of slavery, let the North now make that instrument bend to the cause of freedom and justice.
As we approach the 4th of July this year, and in the spirit of the abolitionist Frederick Douglass, perhaps we can learn to think more about the ways in which the Declaration of Independence and the U.S. Constitution inform and support each other, often in surprising but important ways.
What do you think? Which of these positions is most persuasive to you? Let us know what you think in the comments below.
Before we end, we want to answer one of our most frequently asked questions. Every few years, an old draft or copy of the first official printing of the Declaration seems to pop up somewhere. In 2018, a Declaration broadside was found and sold at auction for $1.2 million. Are there still copies floating around, and could a copy be in your grandparents' attic? The answer is yes. And to find out, we recommend giving Grandma or Grandpa a call to say hi and to see if you can help give it a clean. With that recommendation out of the way, thanks for watching. And if you are interested in finding out more, take a look at our curated reading list in the description. We wish you a happy 4th of July.
The 19th Amendment to the United States Constitution was ratified on August 26, 1920, and it states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. This was a groundbreaking amendment to the Constitution because it granted women the right to vote in all elections. The road to ratification was a long one. The debate surrounding what would eventually become the 19th Amendment spanned 41 years in Congress. Closely connected to the 19th Amendment is the Edmunds-Tucker Act. This was an act of Congress that initially set out to restrict the practice of polygamy in the United States, but also took away women's right to vote in the Utah Territory. This is very significant because women in Utah had had the right to vote for 17 years prior to the passage of the Edmunds-Tucker Act in 1887. A team of student researchers at Utah Valley University has modeled the Edmunds-Tucker Act and portions of the 19th Amendment. Because the ratification process of the 19th Amendment spanned 41 years, the portions we have modeled include everything from the first proposal to the first vote, as well as the final proposal of the amendment.
Working here at the center with something like Quill, I mean, I'm conducting research, and the directors are here to help guide us and to help us navigate things as we go along, but it's really student-led in that we are doing research and we are having to think like graduate students while still being undergraduate students. So I think it's just, I imagine what I've been doing for the last 2 years here at the center is essentially what I would be doing for the first 2 years of a graduate program. So I think it's been just unbelievably helpful in that respect.
So the center has helped me expand the belief of what I'm capable of. Where I first thought it had to be linear and rigid and all I need to do is graduate, the center has helped me expand my belief in what it means to be an undergraduate student. I can be doing research and completing essays and working with professors in a mentorship position more than just a consultant or just an educator. These people are really interested in my future and what I want to bring to eventually all of our futures. I believe the people here in the center believe we're capable of change. So when I talk to them and they're talking to me about what career paths are available or what opportunities are here in the center, they mean it. They're talking to you sincerely and they really do want to see the center make a difference in your life so that you can go on and make differences in the future. And that is something that really opened my mind to the possibilities of what is available to me, and that has been a critical part of being in the center.
My biggest motivator for applying to the center was I felt like I was working on political science, and then when I left school I was doing whatever job to kind of make ends meet. And it's really like a situation where you've got one foot in your education and in the field that you want to study, and then you have another foot that's wherever the wind blows, kind of like I'm just getting by, getting myself through college. And for me, working at the center was a way to get both of my feet into political science and constitutional studies, so I can really just immerse myself in it, and it becomes not only my education and what I'm doing in parts of my free time, but also a means to make money, which has been great. It's allowed me to really excel, I think, and gain an edge in my studies.
One of the great things with the center is always paying attention, not just what you're doing now, but what's next. And a lot of the administrators here provide great mentorship opportunities to us as students. So I've been able to get a better grasp of what can I be expected to be doing in my first year of law school, and keeping that mindset when doing my work here at the center. So understanding that in my first year of law school, I'm going to be doing a lot of research into case law and legislative intent behind some very famous decisions. But being able to understand how to conduct that research, especially within Quill itself, because of the center, I think has helped me just better prepare and have a lot more confidence, knowing that I have a head start in doing the amount of research and the amount of reading that will be expected from me in my first year of law school. So what I would tell any freshman or sophomore in the program with aspirations for law school, I would let them know to take full advantage of the opportunities available here at the center, because the networking opportunities, the relationships you build here, and just the competency that you're going to gain in writing and conducting research is unparalleled at any college institution. Quite frankly, a lot of the research we're doing is comparable to that of any postgraduate institution. So I would tell any freshman or sophomore, if they want to stand out in the application process, whatever their goals after their undergraduate degree is, the Constitutional Studies Center is the absolute best place to be in the best position possible to fully take advantage of any opportunity that they want to seek out.
So I got involved with the center back in August of 2019. What I've been impressed with from day one is the Institute recognizes its contribution to academics, its contribution to you as students, as you view, but they also recognize they've got a blind spot, and it's teaching. With Rod and Andy and Scott, from day one, they're like, we are experts in this, but we don't know what classroom teachers need. What do you need? And that has been so refreshing to work with the university. And not all universities approach high school with questions. Instead, they come more with mandates and saying, this is what we're going to do because this is the need we see, which is a good approach because they do have an expertise about what they need. But what I appreciate about the center is they came and said, this is what we want. What do you need? And that approach has been the best partnership with high schools I've ever worked with.
The 19th Amendment to the United States Constitution was ratified on August 26, 1920, and it states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. This was a groundbreaking amendment to the Constitution because it granted women the right to vote in all elections. The road to ratification was a long one. The debate surrounding what would eventually become the 19th Amendment spanned 41 years in Congress. Closely connected to the 19th Amendment is the Edmunds-Tucker Act. This was an act of Congress that initially set out to restrict the practice of polygamy in the United States, but also took away women's right to vote in the Utah Territory. This is very significant because women in Utah had had the right to vote for 17 years prior to the passage of the Edmunds-Tucker Act in 1887. A team of student researchers at Utah Valley University has modeled the Edmunds-Tucker Act and portions of the 19th Amendment. Because the ratification process of the 19th Amendment spanned 41 years, the portions we have modeled include everything from the first proposal to the first vote, as well as the final proposal of the amendment.
Working here at the center with something like Quill, I mean, I'm conducting research, and the directors are here to help guide us and to help us navigate things as we go along, but it's really student-led in that we are doing research and we are having to think like graduate students while still being undergraduate students. So I think it's just, I imagine what I've been doing for the last 2 years here at the center is essentially what I would be doing for the first 2 years of a graduate program. So I think it's been just unbelievably helpful in that respect.
Good morning and welcome to the Center for Constitutional Studies at Utah Valley University in Orem, Utah for day 2 of our annual First Amendment Conference. This year's conference is entitled Looking Forward, Religious Liberty Under a New Court. I'm Scott Paul. I serve here in the center as interim director and executive director. Speaking on behalf of my colleagues, we are thrilled to spend another day with you considering pressing matters of religious liberty. I extend a special welcome to the high school classes that are joining us today. 2 years ago, the Center for Constitutional Studies launched a K-12 constitutional literacy initiative, which includes, among many other things, bringing high school students to campus for special sessions of our conferences. Since the students can't come to campus, we've invited our high school friends to join us online for this session. They were also invited to join us for a special session yesterday. Now, please allow me just a few words of introduction and acknowledgement. Organized in 2011, the Center for Constitutional Studies is a nonpartisan academic institute that promotes the instruction, study, and research of constitutionalism. Our mission is to increase constitutional literacy in our local, state, and national communities in a nonpartisan manner. Speaking on behalf of my colleagues, I express gratitude to UVU Provost, Dr. Wayne Vaught, and UVU President, Dr. Astrid Tumines, for their support of our center. I also thank members of our advisory board for their invaluable guidance. Several of them were especially helpful in developing this conference. We hope that this is the last annual conference we hold entirely online for many reasons, not the least of which is that you miss out on engaging with the amazing students here in the center. Thanks to the generous support of the National Endowment for the Humanities, the Utah Federalism Commission, and especially the Wood family, the center is home to more than 20 phenomenal student research assistants. They are truly the lifeblood of our organization. Now, regarding our students, to our high school students watching, if you have an interest in government, politics, U.S. history, or the U.S. Constitution, consider coming to UVU and getting involved here with the Center for Constitutional Studies. We'll take good care of you. Now, it's my pleasure to introduce you to the moderator of this session. Matthew Richards is the chair of the First Amendment and Religious Organizations section of Curtin McConkie, Utah's largest law firm. Mr. Richards works collaboratively with business leaders and faith communities. He has a particular expertise in domestic and international religious liberty issues and has published articles and presented at international conferences on those topics. Mr. Richards has been recognized as one of Utah's legal elite and a super lawyer in multiple practice areas. He graduated magna cum laude from the J. Reuben Clark Law School at Brigham Young University and went on to clerk for the Utah Supreme Court. Matt is also a member of the advisory board here at the Center for Constitutional Studies. Matt, thank you for being with us today. Oh, I think we're muted, Matt. There we go.
Can you hear me now?
Very well.
Scott, thank you so much for the invitation to be part of this and for the introduction. And special welcome to all those who are participating with us today, especially those of you who are high school students. We're excited to have you be part of our discussion. And I think that the topic of the topic that we're covering today in this particular panel is about religious freedom from the perspective of religious minorities. And this is an important topic for all of us. And that's true regardless of whatever faith you may have, or if you don't ascribe to a particular faith at all, because religious freedom is important. One of the things that I have loved over my years of studying religious freedom is a quote from the European Court of Human Rights that said that, in my own words, summarizing, it says religious freedom is indissociable from democracy, because it provides a space where all of us can live out the lives according to the dictates that God speaks to our hearts. And that's important for each of us, regardless of our faith tradition. And I'm so pleased today that we have a chance to hear from people of many different faiths and traditions, And we can apply our own experience as we listen to what they have to say and to teach us. In fact, the religious freedom in the United States and around the world is often defined and expanded by the experience of minority faith. So some of the key cases that the United States Supreme Court has addressed over the years come from the experience of people on the fringes of society, and that's because those in majority religions tend to have political power to get what they want in communities and the way that the laws and expectations and the morals are set up. But those who are disenfranchised, those who don't have the ability to speak, often need to test them in the courts, and that's where we get these important decisions. I'm sure that we'll hear about those today. So you didn't come to hear me. Let me introduce our panelists today, and then we'll have a chance to hear from each of them for about 20 minutes, and then we'll have opportunity to ask questions at the end. So if you have questions, please put them in the chat. We're excited to hear from you, and we can have a discussion after hearing from each of the panelists. Today we're going to hear first from Asma Udin. Asma I'm very pleased to have you with us. She is the author of several books and articles touching on this, including When Islam is Not a Religion, Inside America's Fight for Religious Freedom, and The Politics of Vulnerability, How to Heal Muslim-Christian Relations in a Post-Christian America. She's an Inclusive America Project Fellow at the Aspen Institute, where she's leading a project on Muslim-Christian polarization in the US. Ms. Udin was formerly legal counsel at the Beckett Fund for Religious Liberty and has held academic fellowships at Georgetown, UCLA, Brigham Young University Law School. She is also an expert advisor on religious freedom to Organizations for Security and Cooperation of Europe and a term member for the Council on Foreign Relations. Welcome to you. We'll also hear from Mona Polacca. Mona Polacca is an educator, facilitator, and speaker, and she has held posts of responsibility within her community, such as treasurer for her tribe, which is the Colorado River Indian tribe. She's also a master in social work and justice at Arizona State University, and has over 30 years experience working, presenting, and publishing on health and social issues affecting Native American peoples. She serves as a tribal liaison for the Healing of the Border Project of Indigenous Alliance Without Borders, and is currently a senior fellow overseeing the Original Caretakers Program for the Center of Earth Ethics. As the president of the International Council of 13 Indigenous Grandmothers, she works with Indigenous women to preserve and protect Indigenous practices and ceremonies, including the right to use their earth-based medicine. She is a participant in the United Nations Permanent Forum for Indigenous Peoples Issues, and she has assisted in listening sessions with Indigenous peoples. In 2013, at the Permanent Forum, she and others presented an intervention, a call for the Indigenous Women Forum on Water and Peace. And her efforts have included providing support for First Nations to build capacity to take action on climate change, build sustainable communities, protect lands and waters, and conserve biodiversity. Her spiritual practice is grounded in the Havasupai, Hopi, Utiwa original instructions and the Native American Church. And then finally, we're excited to welcome Dr. Michael Helfand. He goes by Abby and is an expert in religious law and religious liberty. A frequent author and lecturer, his work considers how the state treats religious law, custom, and practice. He's a professor of law and vice dean for the faculty and research at Pepperdine Caruso School of Law, as well as interim director of Pepperdine's Law Notebar Institute on Law, Religion, and Ethics. Dr. Helfand is also visiting professor and Oscar Rubenhausen Distinguished Fellow at Yale Law School and a senior research fellow at the Shalom Hartman Institute of North America. He received his Juris Doctorate from Yale Law School and his PhD in political science from Yale University. His academic articles have appeared in numerous law journals, including Yale Law Journal and the New York University Law Review. Professor Helfand is also often provides commentary on clashes between law and religion writing for various general audience publications such as the Wall Street Journal, the Los Angeles Times, USA Today, and others. Welcome to all of you. And Asma, we'll begin with you.
Well, thank you. Thank you, Matt, Scott, and Utah Valley University for inviting me to speak today. This talk actually comes at a great time. My new book, The Politics of Vulnerability, was released just yesterday, and I'm really looking forward to talking with you guys about it today. But before I get to that, I'm actually going to talk about the first book that Matt mentioned, which came out in 2019, and it is titled When Islam is Not a Religion, Inside America's Fight for Religious Freedom. And I went on tour with this book and was traveling all over the country with it for 9 months before the COVID-19 shutdown brought it to a close. And then I took everything I learned from that tour and I put it into my second new book. But before I get to that, what is When Islam is Not a Religion all about? The title may be confusing, maybe even bewildering, but so is a claim that gave rise to it. And that claim is that Islam is not a religion. It is instead a dangerous political ideology, and therefore Muslims do not have rights under the First Amendment. Increasingly, we hear arguments made both in the courts of law and the courts of public opinion that Islam is not a religion, that it is instead a dangerous political ideology that's just hell-bent on taking over the United States. Islam is an almost otherworldly bogeyman in this sort of narrative, a larger-than-life, all-consuming swamp creature. And in the process of stopping it, its opponents run roughshod over the human rights of everyday human beings who happen to be Muslim. So consider some general statistics on the rise of anti-Muslim sentiment. Almost 1 in 5 Americans believe that under the US Constitution, American Muslims do not have the same rights as other American citizens. And Americans favor protecting religious liberty for Christians over other faith groups, ranking Muslims as the least deserving of this right. 82% voted in favor of protecting religious liberty for Christians, while only 61% said the same for Muslims. The general climate of anti-Muslim bias correlates with a sharp rise in hate crimes. Anti-Muslim hate crimes are the fastest growing religious hate crimes. In addition to these hate crimes, more than 42% of Muslim children in grades K through 12 have experienced some type of bullying because of their faith. And all this is made worse because it happened at a time when the country's top leaders were all trumpeting the importance of religious freedom. During the 2016 presidential election, almost all of the Republican presidential candidates positioned themselves as the ultimate defenders of religious liberty. Candidate Trump promised on the campaign trail that the first priority of my administration will be to preserve and protect our religious liberty. And when he was elected, former President Trump did indeed make it a top priority. He opened the Conscience and Religious Freedom Division of the Department of Health and Human Services, issued broad religious liberty guidance, and instituted the Religious Liberty Task Force at the Department of Justice. And then for the last 3 years, the State Department held a multi-day ministerial to advance religious freedom and issued a declaration reasserting the United States' unwavering commitment to promoting and defending religious freedom. But every single one of these measures was in response to the demands of a particular religious group, conservative Christians, and they all took place right alongside a growing climate of anti-Muslim sentiment and hate crimes, and the growing salience of the claim that Islam is not a religion and Muslims don't deserve religious liberty. In fact, even during the 2016 presidential campaign, the presidential candidates were rallying for religious freedom, but they were also proposing staunchly anti-Muslim measures. Trump promised to establish a database to track Muslims and suggested shutting down mosques, and Ted Cruz advocated for surveilling quote-unquote Muslim neighborhoods. Other presidential candidates chimed in too. Ben Carson declared that a Muslim absolutely could not be president, and Rick Santorum said the US Constitution does not protect Muslims because Islam, quote, is different from Christianity. One BuzzFeed report found that since 2015, Republican officials in 49 states have publicly attacked Islam, some even questioning its legitimacy as a religion. Things like an Oklahoma state representative calling Islam a cancer and requiring his Muslim constituents to fill out questionnaires asking whether they beat their wives. The same lawmaker has also said that Islam is not even a religion, it is a social political system that uses a deity to advance its agenda of global conquest. A South Dakota state senator who was then running for the US House of Representatives questioned in an official press release whether the First Amendment applies to Muslims. A 2014 Republican congressional candidate and now congressman from Georgia wrote in 2012 that, quote, Islam would not qualify for First Amendment protection since it is a geopolitical system. And in July 2019, the founder of the Western Conservative Summit and a former Colorado Senate president stood on the summit stage under a banner proclaiming the importance of religious liberty and said, the simplistic approach of simply granting unconditional freedom of religion to a religion that doesn't believe in freedom, and never doubt me, Islam does not, that approach is civilizational suicide, friends. The obvious contradiction between his desire to protect religious freedom and his advocacy against Muslims' rights seemed to elide him. A friend of mine who works with state legislatures to form bipartisan religious freedom caucuses affirms that BuzzFeed's findings reflect a general trend. He told me he estimates that approximately 5 to 10% of state lawmakers hold to some version of the Islam is not a religion belief. None were known in advance to be what he calls bomb throwers, who he said he generally avoided at that point anyway. So you have a set of lawmakers, a bunch of sort of really extreme folks that he kind of avoided, and then the non-extreme folks, among which he said 5 to 10% of those lawmakers actually hold some version of this idea that Islam is not a religion and that Muslims do not deserve religious freedom. And it's not just politicians. Many commentators have noted a lopsided approach to religious liberty at the US Supreme Court. For example, many have noted the difference in how the court approached anti-religious hostility in a Christian case versus a Muslim case. The first, decided on June 4th, 2018, was Masterpiece Cake Shop v. Colorado Civil Rights Commission. Masterpiece involved Jack Phillips, a Christian baker, who refused on religious grounds to bake a wedding cake for a gay couple. The court ruled 7-2 in favor of the Christian baker, holding that the Colorado Civil Rights Commission, in reviewing the gay couple's complaint against the baker, had treated religion with overt hostility, at one point even comparing Phillips to Nazis. This, the court held, was unacceptable. Religion under the US Constitution cannot be treated with so much contempt. The court said the commission's hostility was inconsistent with the First Amendment's guarantee that our laws be applied in a manner that is neutral toward religion. And yet, just 3 weeks later, the court's majority upheld the travel ban despite evidence of prejudice far more egregious than the evidence in Masterpiece. For those of you not familiar with the case, it involved a challenge to Trump's Executive Order 13769, which blocked citizens from 6 majority Muslim states from entering the US. To many Americans, the travel ban was an extension of Trump's long history of anti-Muslim bias. As a layperson in 2011, he tweeted that the Quran teaches tremendous hatred, which absolutely creates a quote-unquote Muslim problem. When he ran for president, he made the Muslim problem central to his campaign. In December 2015, he praised an author for acknowledging quote-unquote Muslim problems. He later declared, I think Islam hates us, and then backed up his statements with policy proposals such as a total and complete shutdown of Muslims entering the United States, warrantless surveillance of American Muslims, closing American mosques, and creating a registry of all Muslims in the US. So this was a backdrop of the travel ban, and there was plenty of reason to conclude that it was based in anti-Muslim bias. But the majority of the court decided instead to defer to the president. For many commentators, the conservative justices who spoke so passionately about anti-Christian bias seemed not to care much when the bias was against Muslims. And then in February 2019, another case made many Americans wonder, in the words of the New York Times editorial board, is religious freedom for Christians only? Alabama executed Dominic Gray, a Muslim death row inmate, without accommodating his request to have an imam in the room with him. The clergy permitted in the execution chamber were limited to the ones on staff, but the prison employed Christian clergy only. Gray challenged the prison's denial on religious liberty grounds. His case made it to the US Supreme Court, which ruled against him and permitted the execution to proceed without the imam. Outside the Supreme Court, legal challenges to Muslims' religious rights are common, especially in the area of religious land use, which is like the ability to build or expand houses of worship and other religious facilities. Perhaps the most egregious example of this is a 2010 case challenging a county approval of building plans for a mosque in Murfreesboro, Tennessee. According to the mosque opponents, Islam was not a religion, and therefore the mosque construction plans did not get to benefit from any of the county or federal laws that protect religious organizations. The Islamic Center of Murfreesboro was unique in that the arguments were actually made in court. But in just about every other scenario where a local Muslim community is trying to build or expand a mosque, they are faced with strong public backlash, much of it centered on this idea of Islam not being a religion. And my contacts at the US Department of Justice have confirmed that this argument comes up in pretty much all of their mosque or Muslim cemetery cases. In the Murfreesboro case, the judge permitted a 6-day hearing in which the plaintiff's attorney literally put Islam on trial. And the DOJ had to file an amicus brief explaining that, quote, under the US Constitution and other federal laws, it is uncontroverted that Islam is a religion and a mosque is a place of religious assembly. The argument that Islam is not a religion also undergirds efforts to prevent Muslim religious arbitration. And finally, in the book, I also discussed the problem of judicial biases and the empirical evidence that Muslims, more than any other religious group, face biased judges. Beyond these examples, my book also looks at other limits on religious freedom, not just for Muslims, but for religious minorities more broadly. I also spend my last chapter on today's culture wars, which have pitted religious freedom against sexual freedom. There, I assess how those culture wars intersect with Islamophobia or anti-Muslim sentiment. Now, when you get to that chapter, this is the last chapter of my previous book, you'll learn that I have litigated and otherwise advocate in support of various conservative Christian claims to religious freedom. I was part of the legal team supporting Hobby Lobby in its case at the US Supreme Court. For those of you who don't know what that case was about, it involved the Hobby Lobby craft stores owned by a fundamentalist Protestant family that objected to covering 2 forms of contraception in the employee health insurance required by the Affordable Care Act. The 2 drugs were the morning after and week after pills, which the Hobby Lobby owners said constituted abortifacients and thus violated their religious beliefs against facilitating abortion. The public response to this case, as with many high-profile cases brought by conservative Christians, was that the religious believers were anti-women, backwards, and a threat to all Americans. Now, the fact that I advocated on behalf of conservative Christians does not necessarily mean that I have any particular sympathy for their religious claim. Instead, I recognize quite simply that I don't have to agree with their beliefs in order to protect them. We can and should protect each of our rights to be wrong. As I learned on my book tour, it was precisely this consistency and integrity in my defense of the principle that opened up the possibility of exchange with many conservative audiences. Remember, my book laid out in detail the ways many conservatives say and do things that hurt Muslims' rights. So why would they invite me into their spaces to tell them about it? In our divisive, tribalized world today, that's exactly what does not happen. We retreat into our safe spaces and block out anyone who thinks differently from us. We not only see these people as wrong, but at times even see them as evil. So why were my exchanges different? I was absolutely fascinated with this question and just started to probe. My conclusion in many ways was simple. Unlike others who criticized their statements and actions, I was coming to these conservative audiences from a place of compassion and consistency. First, I talked to them about their concerns. I cared to engage them and not dismiss them. Instead of saying their religious claims were invalid or mere pretext for bigotry, the oppression of women, and any number of other judgments leveled at conservatives these days, I said, I understand. Your claims are motivated by a sincere religious belief. You are genuinely worried about your ability to live according to those beliefs, and you're not a bad person because you feel that way. And then I told them, look, I'm sticking up for you, even as I call you out for your hostility against Muslims, and in return, I expect you to stick up for my community. I use the language of religious liberty to argue my case, and I saw time and again an opening, a receptivity to listen and be in conversation. So I had these basic observations about the psychology of my conservative audiences, and I wanted to write about it, but I felt that I didn't have the right words to describe what I was seeing. And then my friend, a political scientist, introduced me to the scientific literature on group identity, intergroup bias, and the many studies that look at these things in relation to religion. Suddenly, I had the words I needed. I had a framework, and I set out to write my next book, which came out yesterday, The Politics of Vulnerability. At the core of my thesis is the idea that we are all human and we all act and react in very human ways. First, there is group identity. Our group is the in-group, and those outside our group are the out-group. Our attachment to our group is so significant that the loyalty actually boosts self-esteem. And on the flip side, studies have shown that if we're isolated from our group for whatever reason, the stigma acts on us psychologically and also triggers a physical assault on our body. What this means in practice is that even evolutionarily, humans are programmed to signal their allegiance to their tribe as a way of avoiding this loneliness and stress that comes from being cast out. And second, there's a mechanism of intragroup bias. While it's natural and not harmful for groups to favor their own group, things get a lot more complicated when the in-group starts to experience really strong emotions. Stronger emotions include things like feeling the out-group is moving against you. An out-group seen as threatening may elicit fear and hostile actions, whereas high-status groups, or groups that are a numerical majority and have power, don't feel threatened by minorities. When the status gap is very wide, they are more likely to feel threatened when the status gap is closing. And in fact, the status gap is closing. If we're going to think of white conservative Christians as the in-group that feels threatened, there are many reasons why they feel this way. First, and for the first time in US history, white racial dominance is on the decline. In 1965, white Americans constituted 84% of the US population. Since then, there has been influx of immigrants, with nearly 59 million arriving in the last 50 years alone. Between 1965 and 2015, the American Asian population went from 1.3 million to 18 million, and the Hispanic population went from 8 million to almost 57 million. And now Pew says whites generally will be a minority by 2055, and the US Census says it'll happen even sooner in 2044. And second, also for the first time in US history, white Protestant Christians are a minority in America. A 2017 study found that the white Protestant Christians constitute only 43% of the US population. And to understand the gravity of the shift, consider that in 1976, 8 in 10 Americans were white Christians, and 55% of Americans were white Protestants. In 1996, white Christians still made up 2/3 of the population, and today they don't even constitute a majority. And third, the demise of white Protestant America has brought with it an end to the cultural and institutional world built primarily by white Protestants that dominated American culture until the last decade. Not only is Christianity declining, but so is religion overall. More and more Americans are religiously unaffiliated. And in 2019, the percentage of these unaffiliated became roughly the same as the percentage of evangelicals or Catholics. So altogether, this has precipitated an internal identity crisis that has generated tremendous anger, insecurity, and anxiety. And unfortunately, that anger has been directed towards a number of minority groups, including Muslims. But intergroup bias studies don't just tell us what causes a bias, they also tell us how to solve that hostility that manifests when the in-group feels threatened. And a big part of that solution is empathy. In our increasingly tribal society, each side has its own stories of oppression and victimhood, but tribalism makes conversations about these issues harder because it robs individuals of their humanity and reduces them to members of in-groups and out-groups. And to build connection across difference, we have to be willing to be intentionally with people who are different from us and learn how to listen, have hard conversations, and be more curious than defensive. So speaking purely pragmatically, if we mock or berate conservative Christians for feeling threatened or persecuted, we'll succeed in just making them feel even more threatened, and this in turn will lead to more hostility. So in my book, I talk about empathy as a concrete tool for conflict resolution, but more importantly, I demonstrate empathy in the way that I talk about the concerns the conservative Christians have, as they say, show, don't tell, and I guess I do both of them in my book. I write in a way that communicates how I see others, even those who might engage in hateful acts against my own religious community, as humans. And when I do that, I create openings for real change and real conversations. Thank you.
Thank you so much, Asma. We're so grateful for your review of those books that you've written. It makes me interested. I can't wait to talk more about this, but we'll turn the time over now to Mona Polaka for her presentation.
Thank you. First of all, I'd just like to greet each and every one of you. Good day. I'm grateful to be here, and also like to acknowledge the First Nations and the ancestors of all of the places where we are now speaking from. Myself, I am in Tucson, Arizona. I'm on the traditional lands and territories of the Tohono O'odham Nation. And I am, on my mother's side, I'm from the Havasupai people down at the bottom of the Grand Canyon, the people of the blue-green water, guardians of the Grand Canyon, and Hopi and Tewa Pueblo people of northern Arizona. And in our traditional ways, one of the things that we always speak from is our identity of who we are and where we come from. As part of my identity is the water. I come from this water, the blue-green water of down in the bottom of the canyon, but I'm also from the Colorado River. And so the way we think about it is that everyone that is along the river, that body of water, are my relatives. All of the ones that are within the water are my relatives. And so I acknowledge that that connection. And I'm coming as a Native American, speaking about our religious, or what we usually don't call it religion, but we call it our spiritual practices and beliefs. And the question I'd like to give to you to think about is for you to think about this this First Amendment, the First Amendment of the U.S. Constitution, which protects the freedom of speech, religion, and the press. It also protects the right to peaceful protest and to petition the government. But at this time, it has many interpretations, and there's also been many disputes related to it. And what I would like to mention is, for yourself to reflect on that. Reflect on how are you connected to this in your spiritual or religious practices. I'm speaking from my experience and the historical experience of the Native American people, the original people of North America. And we, as the Native American people, or also referred to as American Indian, we did not receive our rights for our freedom of religion until 1978 from the American Indian Religious Freedom Act. And it was this act then that gave the indigenous people of North America the right to practice our traditional spiritual beliefs and practices. It was against the law for us to do that. Our people, once they were found to be practicing their spiritual ceremonies, they were jailed, they were beaten, they were persecuted. And so we, as the Native Americans, the first people of our country, the United States, did not have that right. But I'd also like to mention that in the U.S. Constitution, there is a special provision in there that speaks to how the United States would interact with the tribes in the United States, and that was the I believe it's called the Intercourse Act, which related to how people would interact with the tribes. And there's another piece in there that also speaks to our relationship and that how the United States Constitution upholds any treaties that the country engages in with other nations. And the tribes of the United States, the tribes that were within the boundaries of the United States, were included in that. And so what that established was that tribes have what is called, or often referred to as, the government to government relationship, that tribes are nations within this nation, and that there were treaties that were entered into throughout time, and that those treaties are considered part of the supreme law of the land. And so I'm not going to get into explaining all that. That would be a good thing for you to look at in terms of our US Constitution. Even though we have this relationship with the United States, we have not enjoyed the honoring of this relationship, the honoring of our treaties being upheld and honored and fulfilled according to those agreements that the United States have entered into. And so when it comes to our freedom of religion, there are certain things that I think are important for the general public to be aware of. When we received our freedom of religion, there were many, many of our tribal nations leaders, spiritual leaders, medicine people, that advocated for this, that went and testified, that spoke, and took great lengths in order for us to be granted our freedom of religion. And so in their efforts, part of that act gives us the right to be able to have our paraphernalia, our sacred ceremonial items. And one of the sacred items that we use in our ceremonies are eagle feathers. And eagle feathers are a treasure to us. They represent an honor. They represent our sacred connection with the Creator. We use them for a blessing. We use them to clear our path. We use them to hold our balance and be grounded physically, mentally, spiritually, and emotionally. And so we have that right to have possession of eagle feathers. And in having that right, in this law, it says that we are the only ones that would have that right to hold these feathers. But in order to have that right, we have to be a member of what's called a federally recognized tribe. And these are tribes that the government, the US government, has established this relationship with, as could be through treaties and different agreements that were made, that gave us this federal recognition by the government. And there's over 500 tribal nations in the United States that have this recognition. There are many more tribes, but they are not federally recognized. They didn't seek recognition. So, but they are still tribal nations. They still have their their homes, their traditional lands, and continue to live where they traditionally have lived from time, we say time immemorial. So so we are able to have the eagle feathers. The other right that we were given was the right to have our earth-based medicine. Our earth-based medicine are the various kinds of herbs that we use in our ceremony or in taking care of ourselves physically, mentally, spiritually, and emotionally. And one of those in particular that is included in that American Indian Religious Freedom Act is peyote. And so only Native American people, according to this act, are legally able to possess and use peyote. And part of that use of the peyote is within the Native American church. And so, so in order to be in line with that act, again, you have to be a member of a federally recognized tribe. We also have, we as American Indians, we have what they call, we have a certificate of Indian blood, which is sort of like our certificate of pedigree. And it states this, this certifies that Mona Palaka is a member of the Colorado River Indian tribe. She is Havasupai, Hopi, and Tewa. And she's 4/4 Indian. That's my pedigree. I'm 4/4, I'm full-blooded Indian. And so I have this card. We also have a card that we carry if we're going to be carry any of our paraphernalia, our eagle feathers or other instruments that we use, our medicine, like the peyote. If we have possession of the peyote, we have to have a card. And so so these are some of the requirements that we as First Nations of the United States comply with. And we, when the act was passed, we agreed to do it. And so that's what we do. We uphold the honor of our relationship with our spiritual practices and beliefs and all of the things that go along with it, which include places like this place I'm in front of, this water, this place, this ground here, the earth. We hold that in a very, very, very sacred and special manner. And so under this law, we stand behind that and we uphold it. One of the things that have been occurring is in relationship to these rights that our people, the elders, the ones before me, stood up for and fought for, are being now being put in a position where the non-native people are saying, give it to me, give me that right, give it to me, I want it, I deserve it, I have the right to have what you have because of my religious freedom. And so this is something that needs to be considered and thought about. The historical efforts that are made and have been made in regard to the American Indian Freedom, the American Indian Religious Freedom Act are very, very specific to our people. There is a history that we have in connection to these things that we use, even the places where we have the ceremony. We have a relationship with that. And so the other thing that comes up when we talk about our spirituality, our religious beliefs and practices is culture. Culture is defined as being, is defined with our relationship, or it means having traditions, beliefs, practices, life ways, art, crafts, and social institutions of my community, our community, and our Indian tribes, or even any local ethnic group. And so whenever we talk about our existence as tribal nations, we always include culture. And part of the reason why we include culture is because it's our practice and our way of life. It's our way of doing things that maintain our sense of identity. And just like this water here, that's my identity. I come from this water. And so I value it, I treasure it, I hold it as sacred. And so when it comes to our people, the indigenous, the Native American people, those are some of the key things that we always will mention. And we also mention our relationship with what we call the sacred foundations of life. And the sacred foundations of life is not anything different than any one of you here in this audience. The sacred foundations of life are the water. We lived inside water in our mother's womb. That was a very special place. It was sacred. That's where our life began. So we always acknowledge the water as our mother water. It's a sacred element. It's life. That's why you hear people saying that now. Water is life. And that's acknowledging it, acknowledging ourselves. And then the air you breathe, the air we breathe, that's our life. We acknowledge it and give thanks to it. And then the sun, the fire, we call the sun is like we call it our father. And it gives life too. We depend on it. and then our Mother Earth, the earth we walk on, the one that gives us life. Those four elements, we call them our sacred foundation of life. And so then that also is how we acknowledge and recognize, honor, and respect a place like this place where I'm from. It's home. If you could sit in front of this kind of water, this water here, and maybe there's a place where you go to, beautiful lake, river, stream, spring. Maybe there's a place like that that you go to, and it gives you this beautiful, wonderful sense of life. And you could look around you and you see the plant life, the animal life, all of this beauty of life that are also part of us. And you get that feeling. Maybe you don't think of it as a sacred feeling. Maybe you don't think of it as a spiritual feeling, that these things have a spirit that you feel. That's what we could say, we feel the spirit of the water. You can feel the spirit of the water in the air when it rains, or the mist coming off the waterfall. You can feel it, how it makes you feel. Same thing with air, fresh air. Same thing when you go out into the sun and it's nice and warm. The same thing as you walk on the Mother Earth, or you pick a fruit off the earth and you can eat it. That relationship, you can hopefully understand. That's what we're talking about when we say it's sacred. That's what we're talking about when we say we have a spiritual connection that is what we call our spiritual practice and belief. And there's certain motions, certain things you do, certain things you offer. My mother told me, when you come upon water like that, when you come upon the water in its natural state, you go to it and you put your fingers in it and you rub your hands together and you touch your heart and touch your mind. You introduce yourself to it. And then you can go ahead and use it. Take some or get into it. You go ahead and do that. That acknowledgement again. That's how we talk about. That's why we say it's sacred. I'm talking about this because that's one of the I believe one of the biggest barriers that we face when we have to go into a court of law that is not of our culture, not of our worldview, not of natural law, but of man-made law. We follow the natural law.
Ms. Polacca, thank you so much for sharing your experience with us. We're so grateful for you and for your perspective. And I look forward to the questions that we'll have for you in our discussion in a few minutes. It's time to turn the time over to Dr. Helfand, who will share with us his perspective. Avi.
Thanks so much, Matt. Really appreciate the introduction, and UVU for hosting. Really a pleasure to be here today. Let me tell you a little bit about what my plan is for the next 20 minutes or so. So my plan is I'm going to try to give you the perspective of American Jewish institutions with respect to religious liberty. And the way I'm going to go about that is I'm going to try and tell you a history of how American Jewish institutions advocated in religious liberty cases through the amicus briefs that they filed. What's an amicus brief? In any court case, you have two parties, typically, sometimes more, A versus B. But sometimes the decision a court's going to make in a particular case also implicates C. And as a result, this third party sometimes will come to the court and say, we also would like to file a brief because what you're going to decide today implicates our interests as well. And as a result, we'd like to tell you some things about the case, about the law, that we think it's important for you to know. And over the years, American Jewish institutions have filed maybe, there's some statistical data on this, as of the early 90s, more than any other faith community in the United States. I'd like to use those documents to try to tell you the story about how American Judaism has viewed religious liberty through the years, how that's changed over time, maybe even a little bit of a theory as to why it's changed over time. And in that way, my goal is to tell you a little bit about the history and the future of religious liberty as seen through the eyes of American Jewish institutions. So that's the game plan. And I'm going to use PowerPoint slides because one of the organizers told me it would be very exciting if I use PowerPoint slides. So let's give it a whirl and see what happens. Fantastic. Hopefully that's working for everyone and you are seeing slides. Matt, does that look like slides?
Yes, we got him. Thank you so much.
Amazing. Okay, fantastic. Okay, so let's start with a little more background. So first thing we have is free exercise doctrine, religious liberty doctrine, free exercise of religion, one of the two religion clauses in the First Amendment. You know, part of this story has to do with the ways in which religious liberty law and doctrine, which I'm sure you've talked about already at the conference, has evolved over time. There have really been three stages, so to speak, of how religious liberty has worked in the United States. The question always is, what is the trigger for a religious liberty claim? And then what does the government need to prove if it wants to say, we get you have a religious liberty claim, but we have something that trumps your claim? And before 1990, the way this worked was the following. The trigger for a religious liberty claim was a substantial burden on religion. I'm not going to say a ton about what that means right now, but some sort of burden on religious practice. And the government could trump a law if it enacted some sort of law, state or federal government, a law that substantially burdened religious exercise in some way or another. The government could still justify that law if it was the least restrictive means to accomplish a compelling government interest, or as I like to say sometimes in human terms, the only way to do something really important. That was before 1990. And as I'm sure you've discussed, at some point in 1990, the Supreme Court changed the trigger for what constitutes a religious liberty claim. It changed it to a law violates the free exercise clause only if it targets religion. So if you have a law targeting religion post-1990 under the First Amendment, what would happen is that law would be unconstitutional unless, again, the government could prove it was the only way to do something really important. 1993 comes along and Congress says, we don't like this new version of the law, this new only targeting religion, as opposed to any time a law merely burdens or substantially burdens religion. We don't like the way in which you've restricted, Supreme Court, the free exercise of religion. And so under a federal statute, the Religious Freedom Restoration Act, we're simply going to say no. We want to go back to the old standards. Then there was a debate. Does this apply to federal law? Does it apply to state law? The Supreme Court intervened. Other states enacted. I don't want to get into all the doctrine. Here's what I do want to focus on. What I want to focus on is what I said at the outset, that there's always a trigger and then there can be a justification, something that will trigger a religious liberty claim, some debate. Have you triggered a right to religious liberty in a particular case? And then if you have proved that as a plaintiff, the government can then justify that religious liberty imposition on religious liberty by showing that it's the only way to do something really important. I want to use those two categories to show the way in which arguments lodged by American Jewish institutions over time have changed. They've shifted from broad consensus within the American Jewish community at the outset over religious liberty to debates within the American Jewish community as to questions on the margin. Could there be a justification for an imposition on religious liberty? That second category. Is it the only way to do something really important? And then to a third stage, a stage I think we live in now, where there is growing dissensus, the opposite of consensus, growing dissensus within the American Jewish community over how to deal with claims at their core, whether or not we can agree that there's an actual religious liberty claim, even before we talk about whether or not the government has a justification for imposing some sort of burden or the targeting of religion. How are we going to do that? Well, I just told you. Here's kind of what the world looks like from the perspective of these amicus briefs. In the 60s and 70s, what you saw within the American Jewish community was broad support of religious liberty claims. But as you moved into the 80s and 90s, you began to see division at the borders of the doctrine. And I'll give you examples soon. And now we have entered a phase where within American Jewish community, you have growing dissensus over the quality of the claim itself. And so let me try and put a little meat on the bones to give you a sense of what this story looks like. Let me begin with the story of consensus. Early on, the 60s and 70s, you had a couple of religious liberty claims that went to the Supreme Court, cases over Sunday closing laws, something that used to exist in almost every jurisdiction where businesses could not operate on Sunday, and Sherbert v. Werner, a case that has to do with unemployment benefits for somebody who was terminated for not working on Saturday, and Wisconsin v. Yoder, a case about compulsory education laws in Wisconsin, where an Amish family said they could not send their kids to school in compliance past elementary school and middle school, because it felt so doing, sending them to public school would ultimately harm their kids, undermine their religious values, and thereby undermine their religious community. Those are the three kind of big cases in this first phase, 60s and 70s. And in all these cases, American Jewish institutions offered robust support for these religious liberty claims. You know, the first case, the Sunday closing laws, was actually filed by Orthodox Jewish merchants. And these Orthodox Jewish merchants said, listen, we have this problem. If you, government, require us to be closed on Sunday, and we're also closed on Saturday, our Sabbath, because of our religious conviction, we have a problem. We're closed 2 days a week. Our competitors are closed 1 day a week. And that presents a economic disadvantage for us. And all American Jewish institutions supported these claims. Here I have the Synagogue Council of America, used to be the umbrella organization for all the different streams of American Judaism: Reform, Conservative, Orthodox, Reconstructionist. The Synagogue Council of America, along with the Jewish Council for Public Affairs, another umbrella organization, many Jewish institutions in the United States. Actually, back in the 60s, it had a different name. It's now called the JCPA. All of these organizations said, listen, this is a problem. You're imposing a heavy burden on the adherents, upon their adherence to their religious beliefs. No good. The Anti-Defamation League and the American Jewish Committee on the right side of the slide, two of what are in American Judaism called the Big Three, the Anti-Defamation League, the American Jewish Committee, and the American Jewish Congress, similarly filed an amicus brief in support of the suit. And saying, again, you're imposing an economic penalty on Jews who are adhering to their Saturday Sabbath. As an aside, the Orthodox Jewish merchants lost the case for reasons that are interesting, maybe something that we'll discuss together another time. In a similar way, in Wisconsin v. Yoder in 1972, Jewish groups from across the ideological, denominational spectrum again supported the Yoder's claim that they should not have to abide by compulsory education laws because of the threat it presented to their religious way of life. On the left, again, the Synagogue Council of America, that umbrella organization of all the rabbinical arms of American Judaism, the American Jewish Congress, maybe one of the biggest powerhouses in religious liberty litigation, or I should say church and state litigation in the 50s and 60s, all noted that this was deeply problematic, that you could only trump religious liberty if you had some sort of incredibly compelling reason for doing so. And on the right, the National Jewish Commission on Law and Public Affairs tied this into a concern more broadly that you were seeing a tide, an increasing tide of government hostility towards religious nonconformists. And in this way, once again, every brief filed by a Jewish institution, every amicus brief, every third-party brief filed supported the claims of the Yoder family, the plaintiffs in the case. Now, that's the 60s and 70s. When you get to the 80s, I don't want to oversell this point. You begin to see division. It's not division all everywhere. This is a quick slide to give you a flavor for it. The 80s were quite the party when it came to religious liberty. Tons and tons of cases started popping up before the Supreme Court for reasons that are interesting. But here, in all these different cases, different fact patterns, you once again had all Jewish institutions filing amicus briefs supporting the claims of religious claimants. And so you still have pretty broad consensus. Hopefully the slide even, gives you a good sense of that. And yet, cracks begin to surface in the 1980s within American Judaism. And let me try to give you two examples of these cracks. The first is a case, presiding bishop of Church of Jesus Christ of Latter-day Saints v. Amos. This is a case from 1986. 1986, a particular institution in Utah, LDS institution in Utah, terminated the employment of an employee because he did not receive a temple recommend. And the employee filed suit, and the institution said, it's okay that we terminated this individual on religious grounds, even though typically in employment, religious discrimination is impossible. But Title VII, which is what provides under federal law protection to employees from religious discrimination, has an exception for religious institutions. Religious institutions are allowed to impose certain kinds of religious standards when it comes to questions of employment and terminate people who don't meet those standards. And actually, the institution ends up winning the case. But what's interesting is the way in which Jewish institutions responded to this case. By and large, I would say Jewish institutions supported the LDS institution, the Deseret Gymnasium, in this case, saying that it makes perfect sense for Congress to enact a law like Title VII and provide an exemption for religious institutions. Providing religious accommodations to religious institutions is as American as apple pie. So claimed most of the Jewish institutions that filed third-party amicus briefs in this case. But you do get one brief from an organization, one of the big three, the Anti-Defamation League, that began to worry about the idea of providing accommodations. The idea of providing accommodations was problematic in their view because of the way in which it gave this unyielding weighting in favor of religious employers, almost that a religious employer could trigger this rule and thereby impose penalties or harms on a third party. And on this logic, the Anti-Defamation League argued that this started looking less like a religious liberty claim and more like we have a separation of church and state problem. The idea that a religious employer would wield such power and such authority, they thought started to look like a breakdown in the wall of separation between church and state. As I said, this view didn't win the day in the case, but it's interesting that you begin to see this claim that separation of church and state worries, what we call the Establishment Clause, began to limit the way in which, or at least the argument was for some of these institutions, ought to limit the scope of religious liberty protections afforded religious claimants. So we begin to see church and state worries as a limiting principle, at least so the argument went when it came to religious liberty. And yet another case, also from the 1980s, famous case, Bob Jones University, that had a policy of expelling students that engaged in interracial dating. And the IRS responded to this policy by pulling their tax-exempt status. This case goes all the way up to the Supreme Court, pits questions of racial discrimination against religious liberty, And it raised serious questions for the American Jewish community. How would they react to this case? You know, on the one hand, there's quite a long story to tell about American Jews being denied access to higher education, questions of quotas within institutions of higher education, certainly great sympathies as a result within the American Jewish community when it came to the question of discriminatory policies within colleges and universities. Yet at the same time, one can certainly imagine the way in which American Jewish institutions might worry. Even if they didn't quite buy into this particular policy, what does it mean if a religious institution has an unpopular view? Does that mean they too can lose their tax exempt status? What does this mean for minority religions as they tangle with majoritarian norms? And so you got to split again within the American Jewish community. Institutions like the Anti-Defamation League and the American Jewish Committee, which is hopefully you've gotten a sense, slide ever so gently on the progressive side of the ideological spectrum, found themselves filing briefs to support the IRS. And in their view, it was because there's simply a compelling government interest that overrides the religious liberty rights of the institution. By contrast, COLPA, which I've mentioned before, lives a little bit more on the ideological right, argued that the challenge here was simply giving the majority the right to impose its majoritarian norms on the minority when it came to religion was problematic and ought to trigger a religious liberty claim that should win the day. Bob Jones University loses the case, but hopefully as you're getting a sense, you're seeing debates on the margins. Everyone agrees there's a claim here. Just we have these worries about the compelling government interest, in this case, racial discrimination in higher education. Is that enough to beat the claim? Nobody challenges the claim itself, but maybe there are limiting principles. This has changed, I would say, over the past 20 years. If somebody said to me, what does American Judaism think about religious liberty? What does that look like? As we enter the 21st century, you know, what I would say is division. The division we began to see in the 80s has moved to the center of these debates. And that really happened, I would say, even in the late 1990s. And let me try to give you an example of what I have in mind. Asma already mentioned Hobby Lobby, the Hobby Lobby case from 2014, the question of the contraception mandate. Should employers be required as part of their obligation to provide health insurance to their employees to also provide certain forms of contraception, or should they be granted a constitutional, I shouldn't say constitutional, Religious Freedom Restoration Act exemption? And here you had Jewish institutions lining up in a way you did not see in the 60s, 70s, 80s, and 90s. Here you had three views. You know, one view was the institutions like Hobby Lobby should be supported. Their religious liberty claim should win the day. And you had some institutions like the American Jewish Committee, Jewish Council for Public Affairs, institutions that shade, as I mentioned, slightly more progressive, saying no, the rights of female employees to free contraception is too important. It ought to trump the religious liberty claim. It almost sounds again like the Bob Jones, you know, the 1980s. Listen, you have a claim, but there are some things that ultimately we think, at least so the institutions thought, were more important. But for the first time, what you began to see is institutions arguing that there was no religious liberty claim at all. You know why? Nobody's telling Hobby Lobby to use contraception. It's a corporation. A corporation can't use contraception. Their decision is simply too attenuated. It's too far down the causal, there's no causal nexus between what Hobby Lobby is doing and the use of contraception, even if they think it's sinful. They don't have to do anything. I've tried to bold some of the language from the amicus brief filed by the Anti-Defamation League and other institutions, questioning whether or not there was a sufficient ground to even identify a religious liberty claim. In Hobby Lobby, you also had many, many Jewish institutions that argued that, simply put, for-profit corporations ought not be granted religious liberty claims. You know, it stands in stark contrast to what I mentioned in the 1960s when the Orthodox Jewish merchants filed suit. Those merchants were for-profit entities. And some of these same organizations back then supported the claims of the Orthodox Jewish merchants. Now, as you began to see these religious liberty rights tangling with the rights of others, some institutions made the move to say we have a bigger problem, And we want to challenge the very religious liberty claim itself. It's a for-profit entity. We're not even going to balance. We ought not balance those rights against compelling government interests. There is no right there in the first place. I fear my time is growing short. I'm going to skip Masterpiece Cake Shop. Please forgive me. We'll do it next time. So where does this leave us right now? Let me try to say 4 quick things. First of all, we continue having, within the American Jewish community, ongoing divide over how to balance the rights of, when we talk about religious liberty claims, in what we might call culture war cases, cases that raise questions about women's rights, LGBT rights, etc., in the way that you kind of see in Hobby Lobby. And this debate is not simply about whether or not there's a limiting principle. Should we say the rights of the LGBT community, women's rights, are simply a compelling government interest that ought to win the day? But instead, there remains and continues to be divide within the American Jewish community, within debate between progressive and more traditionalist Jewish institutions, whether or not there's a religious liberty claim to begin with. I have an example of this, but as I mentioned, time is short. Second, there continues to be debate over the extent to which the Establishment Clause, separation of church and state, should be a limiting principle on religious liberty claims. And here I have in mind cases like Trinity Lutheran Free Comer, more recently Espinoza v. Montana Department of Revenue, whether or not the idea of excluding religious institutions from a government benefit or grant program available to private institutions across the board. Do states have the right to exclude religion? Is that, on the one hand, are you excluding religion in a way that targets religion, violates the Free Exercise Clause? Or is the idea that government funding is going to religious institutions problematic, that undermines the principle of separation of church and state? And like I hopefully express in cases like Amos, the extent to which the Establishment Clause ought to be a limiting principle on religious liberty was debated in the 80s and continues to be debated today in these cases as well. And we'll skip this also. Third, this is to me maybe the most interesting piece of all of this. You know, I mentioned this divide, this growing divide, this polarization in many ways with the American Jewish community when it comes to religious liberty advocacy. A way in which maybe, as you might have noticed, it somewhat tracks the polarization we see more generally with respect to religious liberty in the United States. One area that it has not touched is questions of houses of worship and the ministerial exception. You know, there's growing case law. There's been case law for many years, and the Supreme Court addressed this in 2012 and most recently in 2020. Whether or not houses of worship, when they employ religious either leaders or individuals within the institution who are important to its religious mission, can those institutions hire and fire in ways that don't necessarily comport with anti-discrimination law? Does an Orthodox Jewish synagogue that is committed to only hiring male rabbis, is it allowed to exclude female applicants from the applicant pool? In principle, you can't discriminate on the basis of sex and gender when it comes to hiring and firing. And yet we have a rule, the ministerial exception, that says when religious institutions engage in the hiring and firing of religious leaders, that is part of the protection afforded by the First Amendment. Now, you'd think you might have this may look like a battle again between questions of religious liberty and questions of anti-discrimination law, the protection of other minority groups. Here, interestingly, what we've seen in recent cases, certainly in 2020, is actually broad consensus within the American Jewish community, a worry that the idea that we would limit this category of who is and is not a religious leader, who does relate to the religious mission, an actual worry across the ideological and denominational spectrum that we need to broaden the category of who counts as a minister. And what's interesting about this, at least to me, is you see the pushback from American Jewish institutions about the idea that categories like minister ought to define who is and is not a religious leader. That instead, American Jewish institutions see their religious leadership coming in various types of institutions and from different kinds of people, and kind of majoritarian norms or majoritarian intuitions about who is and is not a religious leader actually don't track the American Jewish experience. And in that way, it fails to recognize, if we don't broaden the constitutional category of who is a minister, what we're ultimately doing is denying the theological experience of the American Jewish community. And that's gotten actually broad appeal within the Jewish community. I mention that because, there's something built into that, some sort of intuition that, at its core, what the American Jewish community, even as it continues to be divided regarding all these other different kinds of questions, when it comes to having its theological experience, the way in which it experiences religious leadership, the way in which it identifies which institutions provide religious meaning, on that, the idea that that experience wouldn't be recognized unites the Jewish community. I think that sounds right to me. That sounds right to me because, ultimately, at its core, a religious minority wants to have its leadership and its people and its institutions recognized. And it doesn't want its experience to have to track the experiences of others. Each community has a method of developing religious continuity, promoting religious experience that is different. And as a result, the one thing that really does continue, I think, to unite the Jewish community is making sure the law recognizes that as well. Thanks so much.
Many thanks, Avi. That very interesting review of the history of the jurisprudence, how the law has formed relating to the free exercise and establishment clause, as well as the Jewish experience. So it's so grateful. I think it's an interesting point to emphasize that not all traditions speak with a common voice. There often is varying opinions among the different groups, and I'm sure that's true of the Muslim and Native American experience, as well as many other faith groups as well. So very helpful. We've received a number of questions in the chat for each of you, and I'm just going to begin with a question for you, Asma, if you'll take this one. There were a number of questions relating to your point about empathy and how do we inculcate it, how do we grow or develop that empathy, and specifically, how do we develop and create more supportive interfaith communities along that principle?
Well, that's a great question. And I think, in my book, I spend much of it kind of laying out the problems that I see. But the solution section is always the hardest section, right? Everybody wants some easy answers. And I try my best in my book and the latest one that came out to provide some guidance on that. But mostly what I do in the book, I sort of mentioned this earlier in my talk as well, this framework of intergroup bias, right? And how it's natural for us to be sort of separated out into our groups. It's a very human phenomenon, and there's nothing inherently bad about it. But I think what the point at which scientists have found that it becomes problematic is when one side feels threatened, right? And the way to then address that is to lower perceptions of threat, right? And we hear this a lot. President Biden, in his repeated calls for healing and unity, has said that we have to, quote unquote, lower the temperature. And that's another way of explaining this phenomenon of lowering people's perception of threat. If the in-group or a group does not feel threatened, they are less likely to react with hostility. And so in the book itself, I demonstrate that in the way that I talk about the concerns of conservative Christians. I'm like, there's very valid reasons for them to feel threatened. And I'm explaining that as just a very human phenomenon. It's not something peculiar. It's not something that, that's a problem for these people to be feeling. Any one of us, if we were in the same position, and different groups, different races and religions are in the same position in a number of other countries outside the US, and they react in the same way. And so the more we can kind of see the way someone's like acting and reacting as a human phenomenon, as opposed to just sort of like judging them on the surface and putting them into categories and then dismissing them, which unfortunately is what I see as the norm these days. I think that's the fundamental starting point, that just try to see them as human, try to understand where they're coming from like a genuine perspective, as opposed to just for, just as a way of gathering information so that you can then offer a rebuttal. And so, it sounds pretty simple, but I think it's a pretty radical and important step that we have to take. And I think that first and foremost, as I do attempt my solution section, I point out that, look, we're in this hopelessly tribalized state of being, so many different types of polarization, but I fundamentally believe that religious polarization has to be different, because it's about religion, and religion, of its very nature, is about trying to sort of figure out the truth and know that there's a higher source and knows the truth that you probably don't fully get, and you're just trying to figure it out in the course of your life. There's something sort of inherently fallible about humans that all religions teach, as I understand it. And I think that should make it different. It should teach us that we should have humility, and hopefully just sort of like being tied to our traditions and understanding others as humans is an important starting point. And in the book itself, I get into a lot more detail.
Thank you. Avi or Mona, do you have any insight on how we build more supportive interfaith communities? Avi, let's start with you if you have any thoughts.
Asma's work on this is probably the gold standard on these issues. I think, touching in, and forcing people to recognize the way in which what they see tracks or similar to, at least from an experience perspective, what others see, even as the facts change and the circumstance change and the context change. I mean, that's the big hope. The hope is to remind people that what they're seeing now is what others saw then, and then trying to find common ground. I think the challenges that come up is obviously that works within religion. It's from the American Jewish communal perspective. Hopefully a little bit of what I said about Bob Jones University gives you a sense of the challenge or the struggle. That sometimes religious minorities see themselves as minorities in different ways. Their experience tracks when they see a particular issue or a particular debate, tracks both parties in some way, and that sometimes generates very complicated, difficult conversations, not just kind of as they try to build interfaith alliances, but also as they try to think about who they are and who do they see themselves in, and those kinds of issues. They're hard. They're just genuinely hard, and that's why I think they persist in deep and important ways.
It seems to me that from both your comments that keys are not overreacting to threats, understanding each other, looking for empathy, making sure that we understand that there are lots of different viewpoints here, and kind of weighing them out and trying to find the common grounds where we can, and finding solutions. Mona, what thoughts do you have? And we just have a few more minutes here before the end of it. So if you could just give us a 30-second perspective, we'd love it.
Well, what I'm seeing here is there's a lot of ecumenical activity among the communities here. And so that the various denominations and religions come together and support one another and have dialogue. I think that's really important.
Great, thank you. So another question for the group. What kind of policy changes do you recommend? We're here where we are, and this is a big question, and because it covers lots of things, but are there one or two things that you recommend that we as a nation or a state, local groups can do to help promote religious freedom and better understanding in our communities? Mona, let's start with you.
Okay. Well, I've had a group and we discussed that. So it's we believe that part of that should be education, creating education and awareness. We believe in starting more at the local level and then, expanding. And so that's the kind of work we're doing right now here in the Tucson area on the border. Feeling the border is part of that.
I love it. Starting local. I think so much of religious freedom and our experience is really just in the local. It happens in our schools and our businesses and how we interact with people in our daily lives. Thank you very much. Avi.
One thing that maybe came through in my presentation is, we're going to have debates over questions of religious liberty, but I certainly think those debates are better when we're not challenging the underlying claims that people make, the quality of their religious claim. This limiting principles we're going to be divided on. I think that's right. But when litigation generates kinds of arguments that make us doubt the good faith claims of other religious communities, I think that's the kind of approach that really makes finding and building either policies or alliances going forward extremely difficult. It's another way of saying that not only do I like big-haired 80s music, but I also like American Jewish advocacy in the 80s more than I do in the present day.
Great, thank you. I think it's super important for all of us to take at face value the claims that are made and respect them and then work within that framework. Asma, what would you add?
So I agree with both Mona and Michael, or Avi, I should say. On the question of education and specifically about what religious freedom even means. I mean, my first book, When Islam is Not a Religion, spent a significant portion, just trying to explain to people what is religious freedom, because I think a lot of people think they know what it means, but they often sort of confuse it with something else, whether it be religious pluralism, or they think that when you're advocating religious freedom for all, that somehow you're saying that anything goes as long as you can justify it on the basis of religion. And it's like, no, there are, as Avi pointed out, limiting principles. And that's just like a basic thing that a lot of people, especially those who advocate against Muslims' rights, fail to realize. And I think also the philosophical roots of religious freedom and this idea of the duty boundedness, the fact that the religious believers absolutely feel a duty to God in terms of like implementing the various sort of teachings of their faith. I think people forget that sometimes. I think it's just like a choice and like, whatever, you don't have to do that. And understanding that duty element and how religion plays an essential role in self-actualization and in our understanding of ourself and the purpose of our life. And I think this also ties back to conclude to the earlier question of empathy, that if we can just see how each of us is on this quest for meaning and purpose in our life, that I think that radically changes, hopefully, the perception of things as a politicized issue to something that's very deeply human and deeply spiritual. Thank you.
Well, thanks to each of you. I have lots of other questions, and I wish we had more time to explore each of them with you and to get your perspectives on them. But I see that we have Scott here with us and back, so I think our time is up. Scott, we'll turn it back over to you.
Right. Well, and thank you, Matt and Asma and Mona and Avi. It's been just a remarkable session. I applaud you all. Thank you for sharing your time and your perspectives with us today. I invite you to move into the post-session breakout room now. For our audience, our final session our final session entitled Looking to the Future will examine religious freedom issues on the horizon and consider how we as a nation might move forward with civility. So please join us for that session in about 30 minutes at 11 a.m. Mountain Daylight Time. Thank you.
Gratitude for this opportunity to speak today and for everybody who's organized this conference. The name of the paper that I've written that I'm basing my talks on is the antithesis of the First Amendment. And so something that Bill just said, I wanted to draw out. He said that people feel now that the government is antithetical to religion. But I want to point out what I think is the real antithesis of the First Amendment. So to start out, since the basis of all of this is the Establishment Clause, I'm going to start out with kind of an exposition of the Establishment Clause. And to start that out, I'm actually going to try and wake you all up by showing you a joke. So here it is. When is a dog overweight? When it's a little husky. Okay, I know it's not terribly funny, but I'm going to take any humor that you might have found in that away from you by asking you to analyze it and ask yourself, why is this joke funny? And obviously it's an ambiguous phrase, a little play on words, but there's a little bit more to it than meets the eye. So I used to work for a professor who was an expert on ambiguity, and he believed that you could use particular grammatical formulas to create quick ambiguity so that advertisers or comedians or people like that could create really witty one-liners really quickly. So one of his tricks I'm going to teach you. So there's a class of words in our language, nouns, that can be both countable and non-countable. So what that means is if it's a countable noun, you use an article, so a pencil, for example. If it's non-countable, then there's no article, so we would never say a water. But there's some words that can go both ways, like chicken. So if you say a chicken, you're talking about a little animal running around on two legs. If you just say chicken, you're talking about meat, right? So this also works with countable nouns versus adjectives. So husky can be both a countable noun, a husky, an animal, right? Or husky, an adjective, saying that you're large, right? So the trick that my professor taught me is that if you wanted to create the ambiguity, you could use a particular grammatical formula, the words a little, and insert that in there, and suddenly nobody can tell if you're talking about the countable noun or the non-countable noun, and you have ambiguity. So usually you don't want to create ambiguity, you usually want to avoid it. But why am I telling you this? Because one of these words in our language happens to be religion. Religion can be both a countable and a non-countable noun. And when you say religion, non-countable, you're talking about all religion. And when you say a religion, you're usually talking about a particular doctrine or group or sect. So why is this important? Because in trying to figure out what the Establishment Clause is saying to us, we've got this word, religion, right? And you notice in the Establishment Clause, there's no a religion. We have a non-countable religion. But it's more complicated because we actually have one of these tricky grammatical formulas in the phrase an establishment of religion that creates a further ambiguity, which I'm going to try to explain to you. So if you look at this word collection of stamps, this is actually an ambiguous phrase, not word, sorry, an ambiguous phrase. If somebody says to you, look at my collection of stamps, there's two possible meanings. They could either be saying, look at my action of collecting stamps, or they could be saying, look at my stamp collection, where stamps is either acting as the direct object of a verbal noun, or stamp is acting as an adjective describing a non-verbal noun. This is actually happening in our Establishment Clause as well. When we say no law respecting an establishment of religion, an establishment of religion is ambiguous. It could either mean the action of establishing religion, where religion is a direct object of a verb, or it could mean a religious establishment where religion is an adjective describing an object, a religious organization. And actually, establishment has a semantic ambiguity as well. It could either mean an officially recognized church, or it could mean something that is established. So we have these two potential ambiguities inside of the Establishment Clause, and when we add them together, we have different outcomes that we could come up with. So we could be either saying there can be no law respecting a religious establishment, with two possible meanings, either a state-sponsored church, a religious establishment, or we'll get to the other one. But or we could be saying that there can be no law respecting establishing religion. And you notice in one case we have a countable religious establishment, in the other case we have a non-countable religion. The third choice that I've written up here, respecting establishing a religion, isn't a plausible interpretation of the Establishment Clause because we have no article before the word religion, respecting establishing a religion. Okay, so a lot of grammar, but what does this all mean? So these two possible ambiguous meanings of the Establishment Clause correspond with the overriding theories that have been competing for official recognition from the beginning of Establishment Clause cases. So I've kind of divided them into two camps. We have the non-preferentialists who say that the Establishment Clause only means that we can't have a national church or a state religion. And then over here on the other side, we have the separationists who say that the Establishment Clause means that we can't establish religion, we can't endorse religion, we can't benefit religion in any way. And then neutrality people fit over here too, because they're saying that we can't aid religion, and if it's giving aid to religion as opposed to irreligion, we have to be neutral. And these quotes I've put down at the bottom are people on both sides that have used the grammar to defend their position. Which brings us to the Engel case. So I'm not going to say a lot about the background because Joanne did a great job of that. But one thing to point out is that in the Engel case, the lower courts found that prayer in schools didn't violate the Constitution because in this particular case, the prayer was non-denominational and they said non-coercive. So, but nowhere in the Engel case do they actually even reference the words of the Establishment Clause. They use two different reasonings in my reading of it. The first one is the precedent of Everson, the first Establishment Clause case that was heard about 15 years before Engel. And in Everson, they use broad language like that there's a wall of separation between church and state. And so in Engel, they also said that prayer is unconstitutional because it violates this wall of separation of church and state. Though, of course, we all know that that's not actually written in the Establishment Clause. And then in Everson, they also use language like the Establishment Clause must at least mean, and they say XXX. The Engel case adds prayer to that. The Establishment Clause must at least mean that the government can't tell you to pray, right? And then they use the purposes that they see through history, as the others have spoken about. They said that established churches in Europe forced people to live a religion a certain way, and if they didn't, then they were persecuted. But if you notice this quote that I've put up here, as has been pointed out, they said the Establishment Clause, unlike the Free Exercise Clause, doesn't depend on any showing of direct compulsion and is violated by the enactment of laws which establish an official religion. But notice, establish an official religion is the third option I showed you earlier, right? That's not a viable interpretation of the Establishment Clause, given that they've added an Article A before religion. So they practically admit in the case that if this was looked under the, they didn't completely admit it, but they said more than likely, and the lower courts found, that if this had been looked at under the Free Exercise Clause, because it was non-denominational and non-coercive, they weren't required to participate, that it more than likely would have been found to be constitutional, but because it's establishing a religion, it's unconstitutional. But the court seems to have completely missed this ambiguity that I tried to explain at the beginning, because throughout the case, they talk about establishing religion and a religious establishment interchangeably with no sort of differentiation at all. So you can see all of the things that I've highlighted in red, they're talking about establishing religion as a verb. So they're establishing religion or religious practices. And everything that I've highlighted in black, they're talking about religious establishments, in particular in history, the establishments that we had in Europe. And here's more. So the court comes up with some sort of kind of hybrid outcome where they use the reasoning behind the first ambiguous meaning that we talked about, a religious establishment, to come out with a result that follows the second ambiguous meaning, so that the government is not allowed to establish religion. But you can't really blame them because they're kind of between a rock and a hard place, right, with these two potential ambiguous meanings of the Establishment Clause. The first one seems, so if you interpret the Establishment Clause to mean just that we can't have a national church or there's no law respecting a religious establishment, then it doesn't really seem to jive with things that were written by Madison, for example, in the Memorial and Remonstrance, which was mentioned earlier, where he was opposed to non-preferential taxes, where people could be taxed and then the money that they raised would be given non-preferentially to all religions, right? So Madison was opposed to this mingling between church and state financially. But on the other hand, if you take the second ambiguous meaning of the Establishment Clause, that religion can't be established or supported or endorsed in any way, then you have this huge contradiction that was pointed out in the dissent of Engel and in many other cases. Then why did the people who wrote the Establishment Clause mention God in the Declaration of Independence? Why did they put the Ten Commandments on the Supreme Court building? Why do they have prayers before Congress, et cetera, et cetera? So what I propose is that to solve this problem, we need to return back to the words of the Establishment Clause and look at them a little bit more closely. So if we do so, we'll recognize that there's actually another potential ambiguity in the Establishment Clause, a third possible reading that's really, until this point, been completely ignored, I think. And so if you notice up here, I've put that respecting is a preposition. Everybody on every side of this battle argues that respecting is a preposition, and in that case, respecting would mean something similar to concerning or with regards to. So they interpret it to say, Congress shall make no law concerning, and then there's this issue about what is an establishment of religion. But if you look in the Oxford English Dictionary, which tells how language was used at the time the Constitution was written, and it's still true today, if you look in a normal dictionary, you can see that respecting has lots of potential syntactic functions, and one of them is that respecting could potentially be a verb in the present participial form, which just means you have ing on the end of your verb. So if respecting is a verb, this adds another piece to the puzzle. How do we tell what's really going on here? We have all these potential ambiguities. So how do we tell which one is the right one? Well, my other proposal is that the clue to the resolution of these ambiguities is actually right inside the First Amendment, and that if we don't look at the Establishment Clause in isolation, but look at the whole religious clause, then we can figure out what it's supposed to be saying. So if you look at the Free Exercise Clause, it's very clear that prohibiting is a participial verb. There's no other choice whatsoever. And so when you're learning English, for example, I guess they said I'm an English professor in my previous life, you're taught that the best grammar uses parallel grammatical phrases. So if you consider that respecting is also a participial verb, suddenly you have the Establishment Clause and the Free Exercise Clause as grammatical or parallel grammatical phrases. But it's even better than this, because once you notice that you have these two parallel grammatical phrases, you can also see that the First Amendment, I believe, is a rhetorical figure that we call antithesis. So let me explain antithesis a little bit. Antithesis is when you have two parallel grammatical phrases that are joined by conjunction, and the two phrases with exactly equal grammar have opposite meanings. So this is an example from the Bible, and there's lots of these in the Bible. If you look at the top part, you have a subject, a verb, a phrasal verb, and an object, and then the bottom you have a subject, phrasal verb, object. Equal grammatical phrases, but they have opposite meanings. So if you look at the religion clause, you can also see that you would have a participial verb and another participial verb with exactly parallel grammatical phrases, and that they have opposite meanings, joined by a conjunction. They even have the same amount of syllables, which is another thing that people use. But the opposite meanings are, the Establishment Clause says you don't give special favors to a religious organization, and the Free Exercise Clause or I think I said that backwards. Let me start over, sorry. So the Establishment Clause says that you can't give special favors to religion, and the Free Exercise Clause says that you can't give special disabilities. I hope you're following me because I think I forgot to say something. So let me jump in here quickly and fix something quickly. So if you assume that respecting is a verb, it erases the ambiguity in an establishment of religion, because suddenly you can't have two verbs in a row. It's just not possible. You can't say respecting, establishing, right? Suddenly, an establishment of religion very clearly becomes a religious establishment. And like I said before, a religious establishment has two ambiguous meanings, and one could be any religious organization. So hopefully that clears things up. So the evidence behind this, first of all, if you consider the historical time period when the Establishment Clause was written, it's a period in the English language called the beginning of the late modern English. Late modern English was transitioning right out of early modern English, during which the King James Version of the Bible and Shakespeare were written. Shakespeare wasn't written, Shakespeare wrote. But so during the early modern English period, people were actually taught how to use rhetorical figures in school, for example. It wasn't some sort of accident that these kind of things happen. And also, if you look at the history of the drafting of the First Amendment, you can see that there were several drafts. We have notes that talk about all the different drafts and the reasons that they wrote them all. There are no notes for the final version of the Establishment Clause, why they came out with the final words that they did. But when you consider how carefully they considered every word, and when you consider that the founders were the very elite of society at a time when people were obsessed with rhetoric, and also at this time, the beginning of late modern English, this is a time when people were very concerned about ruling the English language, which means that they started writing the first grammars that were ever written, and the first dictionaries, Samuel Johnson's dictionary and Noah Webster's dictionary, they all came out right about this time. If you consider these things, then it seems more than a likeliness to me. It's more than a likelihood. It seems nearly certain that these men would have considered that the grammar and the rhetoric when they were writing the Establishment Clause, and this isn't some sort of amazing accident. So I think reading respecting as a verb is the most grammatically accurate and the most rhetorically powerful of the ambiguities, which makes me believe that that is the one that was intended. So what does this all mean? So if you look at this slide down here, down at the bottom, if you consider that respecting is a verb, then you could paraphrase the Establishment Clause something like, Congress shall make no law showing regard for a religious organization, any religious organization of any religion, not just one national church. I believe that this solves the problem of the contradiction that we have with the government officially recognizing all of these religious symbols in spite of being prohibited from establishing religion. Because if you consider that it's prohibiting Congress from showing regard for a religious organization, it says nothing about religion non-countable, religion generically, or religion in general, right? You can't show respect for a religious organization, but what about general religious symbols or religious observances? I think those things would be allowed under this reading. And I think it also solves the problem that Madison talked about, that you can't give non-preferential aid to religion because it creates an institutional divide between the institutions, the organizations of religion, and the institutions of government. So there's none of this financial mingling and all of the issues that brings. And then bring it full circle to Engel. What does this mean in the Engel case? My personal, well, first let me say that this is kind of my new theory that the Establishment Clause should be interpreted this way. But I'm not proposing that this is just going to suddenly solve all of the problems, right? Every case you have to look at the facts, and there will be lots of questions. But I think that it changes our starting point and gives us a place where we can start and come to better answers than this catch-22 that we've been stuck in until this point. But because school prayer is not showing respect for any particular religious organization, but is promoting prayer or religion generically, my feeling is that in this case, that school prayer would probably be found to be constitutional. On the other hand, they mention in the case that under the free exercise clause, like I said, if you look at the free exercise clause, they said because there's no compulsion, then it probably doesn't violate the free exercise clause. But there's a little section in the case that says maybe the peer pressure or the pressure you would feel in school that you would need to participate in this prayer could be considered to be compulsion. So in my view, under this analysis of the Establishment Clause, this becomes not a question of Establishment Clause. This becomes a question of the Free Exercise Clause. It becomes a question of compulsion. Is there pressure or compulsion or to participate in prayer in schools under the Free Exercise Clause? Just as the Free Speech Clause allows you either to say whatever you want and not to be forced to say something in particular, the Free Exercise Clause can go both ways as well. You can either be forced to, you can have freedom from being forced to say certain things, as well as you can have freedom to be not compelled to do certain things. Does that make sense? I hope. Anyways, so hopefully that makes sense. That's everything. So thank you.
Good morning and welcome to the Center for Constitutional Studies at Utah Valley University in Orem, Utah, for the final session of our 2021 annual First Amendment Conference entitled Looking Forward, Religious Liberty Under a New Court. I'm Kiana McAllister. I'm the student lead on the Quill Project, our center's research partnership with the University of Oxford. Speaking on behalf of my colleagues, we are thrilled to spend these 2 days with you considering pressing issues of religious liberty and how these issues may be affected by the new U.S. Supreme Court. Now, please allow me a few words of introduction and acknowledgement. Organized in 2011, the Center for Constitutional Studies is a nonpartisan academic institute that promotes the instruction, study, and research of constitutionalism. Our mission is to increase constitutional literacy in our local, state, and national communities in a nonpartisan manner. Speaking on behalf of all my colleagues, I express gratitude to UVU Provost Dr. Wayne Vaught and UVU President Dr. Astrid Jimenez for their support of our center. I also thank the members of our advisory board for their invaluable guidance. Several of them were especially helpful in developing this conference. I hope you've been able to enjoy the first 4 sessions of the conference. If you've missed any of them, check back next week at uvu.edu/ccs/events or on this YouTube channel for recordings of the sessions at this conference. Now it is my pleasure to introduce you to the moderator of this session. Dr. Brian Birch is director of the Center for the Study of Ethics and Religious Studies program at Utah Valley University. His areas of specialization include religious diversity, comparative theological studies, and the dynamics of religion in civil society. He has served on the board of trustees and the executive committee for the Parliament of the World's Religions and is currently a senior research fellow at the Foundation for Religious Diplomacy. He is the founding editor of the journal Teaching Ethics, and his published work includes contributions to the Encyclopedia of Religion and War, Philosophical Investigations, and Dialogue. His book projects include titles ranging from What is Postmodernism to Perspectives on Mormon Theology. His current project is entitled Radical Pluralism, Essays in Ethical and Religious Diversity. Dr. Birch, thank you for joining us today.
Thank you, Kiana. It's my pleasure to be here. I'm grateful to be part of this session, and I would like to extend my congratulations to you and to all of those associated with this event. It's really terrific, and it's been a great couple of days. This is the final session of the conference, and we're privileged to hear from 2 remarkable presenters, both of whom I think would consider themselves friends to UVU and to the Center for Constitutional Studies. We certainly consider them friends and appreciate all they have done to enrich our university. We will first hear from Dr. Philip Munoz. He will present remarks entitled Religious Freedom Issues on the Horizon for the Court, after which we will hear from Judge Thomas Griffith, whose remarks are entitled Moving Forward with Civility. I will introduce each of them, and then they will present in turn, and then we will spend the remainder of our time with questions. Dr. Munoz is the Tocqueville Associate Professor of Political Science and Associate Professor of Law at the University of Notre Dame. He is the founding director of Notre Dame's minor in Constitutional Studies and also directs the university's Tocqueville program for inquiry into religion and public life. Dr. Munoz writes and teaches across fields of constitutional law, American politics, and political philosophy, with a focus on religious liberty and the American founding. His first book, God and the Founders, won the Hubert Morkin Award from the American Political Science Association for Best Book in 2009 and 2010. More recently, in 2019, he joined the editorial team of American Constitutional Law, which I learned is the leading publication for constitutional law casebooks designed for undergraduate instruction. And that publication is now in its 11th edition. Dr. Munoz has spoken at over 75 colleges and universities, notably including UVU. He received his BA from Claremont McKenna College, his MA from Boston College, and his PhD from Claremont Graduate School. And I must note that I am all the more honored to be in a session with a fellow alumnus from Claremont. So welcome back to UVU, Dr. Munoz. Thomas Griffith was appointed to the United States Court of Appeals for the DC Circuit by President George W. Bush in 2005. He served in this capacity until his retirement from the bench this past year. Judge Griffith graduated from Brigham Young University and the University of Virginia Law School. At the time of his appointment to the DC Circuit, he was general counsel for BYU, and prior to this served as legal counsel to the United States Senate, which some of you know is the nonpartisan chief legal officer for this body. He was also a litigation partner at the law firm of Wiley, Rain, and Fielding in Washington, D.C. Judge Griffith is currently a lecturer at Harvard Law School, special counsel at the law firm of Hunton Andrews Kurth, and a senior policy advisor at the National Institute for Civil Discourse. So welcome back to you, Tom. It's great to have both of you here for this conference. As I mentioned, we'll hear from both of our speakers in turn. We'll spend the remainder of time engaging with interesting questions, we hope. And so without further ado, we will turn the virtual lectern over to Dr. Munoz.
Well, thank you very much, Professor Berth. It's a real honor and pleasure to be on the panel with Judge Griffith. And thank you, Kiana, too, for the serving as our moderator here. I am extraordinarily pleased to have been invited to participate in this conference on the future of the First Amendment. I want to thank the organizers. Also want to take a moment to pause and thank the leadership, recognize the leadership of UVU and the university's benefactors for supporting the Center for Constitutional Studies. I run a similar program here at Notre Dame, and I truly believe that knowledge of our constitutional principles, our constitution structure, knowledge of the rights the Constitution is meant to protect, this knowledge is essential if we are to maintain our constitutional republic. So conferences like this one, the education of the public more generally about the Constitution, these are vital components of our system of government and essential tasks for higher education. So I just want to commend UVU on taking a leading role in this civic task. And I'm delighted to be at UVU again, even though I very much wish I could be there in person. She'll be mad at me for saying this, but my niece is one of the assistant coaches on the volleyball team. So I have a special connection to UVU. Okay, I've been asked to share a few reflections on religious freedom issues on the horizon for the Supreme Court. I was particularly pleased to have been invited to speak on this theme, as it's really candidly not my area of expertise. I tend to look backwards in time. I'm a scholar of the American founding and of the original meaning and natural rights principles that originally animated the First Amendment. So I welcome the opportunity to look forward. I want to admit that someone perhaps who's more involved in the day-to-day business of constitutional litigation could better tell us about particular cases that are going to come before the court. So I thought I might approach the subject in a slightly different way. Rather than look at cases in the pipeline or likely to be put in the pipeline, I thought I might step back and try to point out some big issues that the court might take up, should it choose to do so. This is speculative on my part. In a way, it's kind of like what I'd like to see the court, questions I would like to see the court answer. So I've organized my presentation here around two questions each for the Free Exercise Clause and the Establishment Clause. And I'll start with the Free Exercise Clause. Here's my first question. Will the Supreme Court overturn Employment Division versus Smith? Given the current Fulton case, and there's been lots of discussion at this conference on this case, but given the current case, will the court overturn the Smith decision? I don't think the court will overturn Smith in this case. I think that in part because the court could decide for the religious appellants without actually overturning Smith. But even if Smith is not overturned this year, there's going to be calls for the Smith decision to be overturned in subsequent cases. So my question, will the Supreme Court overturn Smith sooner or later? There might be added political incentive to do so. Things have changed for religious freedom in America. Let me point out two things. First, and this has been much remarked at by social scientists, the collapse of the traditional religious character of the American people and the corresponding rise of the nones, not Catholic nuns, but nuns, N-O-N-E-S, that is those who do not identify as religious or affiliate with the church. The nuns, this demographic part of America is growing rapidly, and this fact has been much commented on, so much so that I think it's actually fair to call America, at least our culture right now, we're entering into a post-Christian era. Okay, so we have a demographic fact that the context of religious freedom is different now in America. The second contextual fact, the Equality Act. This is the non-discrimination legislation that has passed the House and is currently being debated in the Senate. The version that passed the House explicitly trumps the Religious Freedom Restoration Act. You probably know this already, but the 1993 Religious Freedom Restoration Act significantly mitigated the effects of the Smith decision, at least on the federal level. The protections that religious citizens lost in Smith were largely restored by RFRA. That's why it's called the Religious Freedom Restoration Act. The act was designed in its author's intentions to restore religious freedom. That is to go back to the pre-Smith understanding of religious freedom. The mainstream Democratic left no longer supports RFRA, and RFRA protections are now seen by many progressives as regressive, as unjust and discriminatory. And hence, when the progressive left is in control of the government, as it is now, RFRA will be targeted for limitation. This is what's happening in the Equality Act. If the Equality Act it is passed, at least in the context of the protections afforded by the Equality Act, RFRA is superseded. It would not surprise me if eventually those on the left called for RFRA's repeal entirely. Okay, for the Supreme Court, this means that the Smith precedent becomes even more consequential. If the Supreme Court does not overturn Smith, religious citizens will, I think sooner or later, likely lose the protections for religious freedom that they have been accustomed to, that they've had for most of the last 30 years, and prior to Smith, 30 years before that. So there may be political reasons now to overturn Smith that did not exist before. Okay, my second question. If the Supreme Court does overturn Smith, how will it do so? This is a little bit of inside baseball, but I thought I might point it out anyways. My question is really, what reasoning will the court use if it overturns Smith? The court's conservatives right now are the justices most likely to overturn Smith. They are also, in general, sympathetic to what's known as originalism, a constitutional philosophy of interpreting the Constitution according to its original meaning. But here's the problem. It's by no means clear that the original meaning of the Free Exercise Clause is inconsistent with Smith. There's lots of originalist criticism of the Smith decision, but that criticism overlooks the fact or forgets the fact that Justice Scalia provided an originalist defense of Smith in the 1997 case, City of Boerne versus Flores. Now, Justice Scalia may be right or he may be wrong. Leading originalist scholars are divided on the question of whether the Free Exercise Clause, its original meaning, affords a constitutional right to exemptions. But there are leading scholars who say Smith was, leading originalist scholars, and I'm thinking here primarily of Philip Hamburger at Columbia, arguably the most distinguished conservative legal historian in the legal academy. There are leading constitutional scholars that say Smith was rightly decided on originalist grounds. Now there are leading scholars, and I'm thinking here now of Michael McConnell at Stanford Law School, who say Smith was wrongly decided on originalist grounds. I don't know that the court can rely on originalism given the scholarly dispute. So if the court's originalists overturn Smith, how will they do so? I don't know. I'm very curious to see. Okay, let me shift to the Establishment Clause. My first Establishment Clause question is, will the current court overturn Lemon v. Kurtzman or any of its progeny, including the endorsement test? The Lemon test has been called a lemon by conservatives for, probably 50 years. Lemon is a three-part test invented by the court in 1971 to enforce the no establishment provision of the First Amendment. The test, you probably know this if you're watching, but the test says for law to be constitutional, a law must have a secular legislative purpose. The primary effects of the law can neither advance nor inhibit religion, and the law cannot cause excessive entanglement between religion and the government. And to be constitutional, a law has to pass all three prongs of the test. Justice O'Connor, in a series of decisions starting in the 1980s, modified or transformed Lemon into what's known as the endorsement test. That is, government cannot constitutionally endorse religion. Now, critics have long argued that these tests don't match the Constitution's text. In an obvious sense, the First Amendment prohibits an establishment of religion. It doesn't prohibit endorsements of religion. Critics have long argued that these tests do not capture the Establishment Clause's original meaning. And here, the original scholars are agreed. These tests are a departure from the Constitution's original meaning. But there's never been 5 votes to overturn either the endorsement rationale or the Lemon test. With Justice Barrett on the court, there now may be. We have Justice Barrett, Justice Thomas, Alito, Gorsuch, and Kavanaugh. I can count to 5. And I've left out Justice Roberts. So I don't know whether the Lemon test or the endorsement test will be explicitly overturned, but it's now possible in a way that it hasn't been possible in the past. So we shall see. Okay, this brings me to my next and final question. Who will be the dominant justice in Establishment Clause jurisprudence? For about 20 years, Justice O'Connor was the 5th and deciding vote on Establishment Clause matters. In more recent years, it seems to be Chief Justice Roberts, that he's held the central position. With the court's new composition, that is with the addition of Justice Barrett and Justice Ginsburg's departure, rest her soul, a new 5-member majority can be formed without Justice Roberts. So who's going to dominate that 5-member majority? Will there be one justice that dominates? I'm not sure. There's an interesting split among the court conservatives on the Establishment Clause. And we saw this last term in the case Espinoza versus Montana. In that case, the court found unconstitutional the application of a Montana state constitutional provision that effectively excluded religious individuals from participating in a state-funded scholarship program. The court, in an opinion drafted by Justice Roberts, said that disqualifying otherwise eligible recipients from a public benefit solely because of their religious character imposes a penalty on the free exercise of religion. And he said that triggers strict scrutiny, and then in the case, they struck down the application of the Montana Blaine Amendment. Now, Justice Thomas agreed with the outcome of the case, but he took a very different approach to the case than did Chief Justice Roberts. Justice Thomas wrote a sharp concurring opinion, which was joined by Justice Gorsuch, and he declared, that is, Justice Thomas declared that in his view, the court's Establishment Clause precedents, going all the way back to Everson versus Board of Education, 1947 case, all these precedents were unmoored from the original meaning of the First Amendment and therefore should be overturned. In a series of opinions dating back at least 20 years, Justice Thomas has argued that the original meaning of the Establishment Clause primarily concerned federalism. That is, the original purpose of the Establishment Clause was to protect the states against federal encroachment in their ability to establish or not establish a religion. So to apply the Establishment Clause against the states, Justice Thomas says, is a constitutional mistake. The logical implication of Justice Thomas's position is the disincorporation of the Establishment Clause. As far as I know, no provision in the Bill of Rights has ever been disincorporated. If Justice Thomas had his way, states would be free to aid religion or not, subject only to the restrictions imposed by their own state constitutions. So let me summarize. Justice Thomas basically would overturn every major Supreme Court Establishment Clause precedent. Justice Roberts, by contrast, seems unwilling to overturn any precedents. So my question, which justice will dominate the Establishment Clause? Will it be Roberts? Will it be Thomas? Or will it be Barrett or Alito or Gorsuch or Kavanaugh? We could have a very different Establishment Clause jurisprudence in the very near future. Only time will tell. Okay, these are just some of the questions I think are before the court. I've probably gone long enough, and I'm eager to hear Judge Griffiths. So let me conclude again by thanking UVU's Center for Constitutional Studies, and I very much look forward to our conversation.
Great, thank you very much, Professor. That was fascinating. And the audience doesn't need to hear this, but I'll say it anyway. You want to find everything that Professor Munoz has written about the religion clauses of the Constitution. His work is groundbreaking, important, and it's an honor to be on the same panel with him. Thank you to the organizers of the conference. Thank you, Kiana, for great work you've done and others have done. And Professor Birch, thank you for that introduction. As the last speaker, I wish I could sound a more optimistic note, but I'm going to start off as a bit of a downer here. Maybe it's my age, 66 years old. Maybe I've turned into a cranky old man who tells young people to get off the grass. But I'm deeply concerned about the present state of American political society and whether we have the capacity in our present state to strike the types of accommodations that will be necessary to guarantee a robust protection of the religion clauses, as well as to guarantee a robust protection of equality principles that are so central to our republic. So I'm worried about that. So let me start. I have a book that I highly recommend. I guess you can't see it really well. I don't have a share screen. I don't know how to do share screen yet. So Political Tribes by Professor Amy Chua of Yale Law School. Professor Chua published this book a couple of years ago. She tells an interesting story in the research and writing the book. She started the book as an effort, as a critique of American foreign policy. And the idea that she wanted to explore was that American foreign policy makers had not taken adequate account of political tribalism in nations where there was some American intervention. She was going to look at Southeast Asia, going to look at Iraq, and different places around the world where American foreign policy had intervened, and critique that because they hadn't taken account of the political tribalism that divided those countries. She put together a matrix of factors to determine whether tribalism had beset a nation. And as she was doing the research and put together this matrix, she came to the rather sober realization that the matrix she created, when applied to her own country, the United States of America, showed that political tribalism existed here, maybe even was dominant. A sober note to begin with. I also want to start with Jonathan Haidt, the author of The Righteous Mind, Why Good People Are Divided by Politics and Religion. I don't think anyone would accuse Jonathan Haidt of being apocalyptic in his approach. Yet listen to what he said just 2 years ago. There is a very good chance that in the next 30 years, we will have a catastrophic failure of our democracy. We just don't know what a democracy looks like when you drain all trust out of the system. So I'm neither a scholar nor a pundit, but I'm an observer. I'm a creature of Washington, D.C. It's where most of my professional life was spent, and I'm a junkie. I listen to C-SPAN radio. You didn't know there was a C-SPAN radio but political junkies do. So with that qualification, let me give you my observation. I don't believe there's been a more perilous moment in my lifetime for our republic than the moment we face right now, because of the warning Professor Haight delivered. We just don't know what happens to a democracy when all trust is drained out of the system. I think we live in that moment now where most of the trust is drained. And so I worry. I worry about our ability to protect religious liberty, to protect equality. So what to do? What to do about the problem? Well, at a minimum, we should act civilly, right? We should carry on our debates civilly. I like this from Peter Wehner. Wehner writes, civility has to do with the respect we owe others as fellow human beings. It establishes limits so we don't treat opponents as enemies. It's a good start. Civility is a good start. Arthur Brooks observes, however, that if he were to tell you that he and his wife were civil one to another, your response would be, get some counseling, right? Civility is the floor, but it's not enough. It's not enough at this present moment. And so I'd like to rely on a work of scholarship by former Utah Valley University President Matthew Holland, Bonds of Affection, it's titled, Civic Charity and the Making of America. It's a fabulous book. I'd highly recommend it. I have a copy of it here as well. Bonds of Affection by President Holland. Professor Holland's thesis is he takes this idea that's part of the American DNA that he calls civic charity, and he traces it from the Massachusetts Bay Colony right on through to Lincoln's 2 inaugural addresses. And the point and he even includes Thomas Jefferson's inaugural address after the bitter election of 1800 has these themes of civic charity. They're best characterized in Lincoln's 2 inaugurals. In the first inaugural, we know he famously said, remember, this is when 7 states have seceded from the Union. The project seems to be on the verge of failure, and Lincoln pled with his fellow citizens. We know these words, they're canonical in American politics. We are not enemies, but friends. We must not be enemies. Though passion may have strained, it must not break our bonds of affection. Then 4 years later, at his second inaugural, on the verge of victory in the Civil War, when Lincoln and the United States had every right, seemingly, to be the conquerors, to crush the rebellious Confederacy. Instead, these are the words Lincoln uttered: with malice towards none, with charity for all, let us strive to bind up the nation's wounds. So Matt Holland's book traces this idea of civic charity, and argues that it was indispensable in the making of America, and then argues it ought to be critical in the project to this day. So what I'd like to do is take that concept, and I'd like to drill down on an event in American history that I think illuminates the importance of civic charity, as well as giving us insights into how the Constitution is intended to work. And I'm going to go back to the Philadelphia Convention of 1787. I'm going to rely on the scholarship of a young scholar named Derek Webb, who studied under Professor and former Judge Michael McConnell at Stanford. Webb drills down into the small group dynamics that characterized the success of the Philadelphia Convention in 1787. He starts with July, and as we know, in July, things weren't looking too well. The convention was on the brink of failure. There was talk of dissolution. Some of the delegates were packing their bags, ready to head out. Things weren't looking good. And yet by September, 7 or 8 weeks later, they had achieved success. In transmitting the Constitution to the Congress, this is what George Washington wrote about their success. He wrote, "The Constitution is the result of the spirit of amity and mutual deference which the peculiarity of our political situation rendered indispensable. The spirit of amity, the spirit of mutual deference, which the peculiarity of our political situation rendered indispensable. Derek Webb does a deep dive to try and figure out how did the convention create that spirit of amity and mutual deference. And he has a couple of suggestions, some insights that I think are valuable for us as understanding history, and I think even more importantly for our present moment. First of all, he looks at the rules of the convention. And the rules of the convention were designed to do at least two things. First was to get the delegates to pay attention to one another. Attendance was mandatory. If you were in Philadelphia, you had to be there. Second, when the floor was held, no talking was allowed, no reading was allowed, no working was allowed. In other words, the value that was intended to be captured by these rules were we are going to listen seriously to one another. The second set of rules created an atmosphere, a space, we would say today, where the delegates felt the freedom to change their views. As we know, the proceedings were in secret. There was no media covering what they were doing. There was no official record of votes taken. So a delegate could take a position in late May and change his view a couple of months later when that issue was revisited without any fear of being called a flip-flopper. Again, the idea was we're going to have a discussion. People are going to listen to one another, and you're going to be able to change your mind. That's the purpose of deliberation. That's the purpose of discussion. So that's the first thing that Derek Webb looks at, is the rules of the convention and how they were intended to encourage, may even force deliberation and consultation. The second factor he looks at is even more interesting, I think, and that is the degree of sociality which the delegates experienced among one another. First of all, start with the idea that even though it was a large city for its time, Philadelphia was a pretty small place. Not a lot of boarding houses or taverns that could accommodate the work of the convention. And so the delegates were housed together in this small city, sometimes sleeping in the same bed with one another, doubling up and tripling up in rooms. They got to know each other quite well by having to live with each other in such close quarters. The typical week of a convention, they would meet at 10 in the morning and work till 3 or 4 in the afternoon in session, Mondays through Saturdays. And then they would break and they would go eat. And then they would have tea afterwards in the evening. Same thing happened with the eating arrangements. There weren't that many taverns available. And so they ended up eating together. And within a couple of weeks of the convention starting, they formed dinner groups. And now these dinner groups weren't formed along ideological lines or even regional lines. It turns out that they would have dinner with people that they hadn't known before from different parts of the country, different regional interests. And then at key moments during the summer, Benjamin Franklin, who lived in Philadelphia and had a rather nice home, would throw a lavish party with the best food that he could find. Libations flowed freely. There was a great deal of good humor and fun and loud laughter. George Mason wrote of this combination of sociality. He said, "We grew into some acquaintance with each other and formed a proper correspondence of sentiments." We would phrase that as they got to know each other. They became friends. So the key moment of the convention, according to Webb, it occurs in July when things are looking dark, like the convention is not going to succeed. A critical decision was made by the delegates. And that decision was that they were going to come up with a compromise. They were going to come up with a compromise so that the conventions would succeed, a constitution would be created, and a republic could be formed. 11 moderates were chosen to meet and hash out this compromise. And they did so in Franklin's home, once again. Small group dynamics among people who had gotten to know each other and could call one another friends. Now, here's the lesson. Here's the takeaway from Derek Webb's scholarship. The delegates at the Philadelphia Convention agreed to compromise for the sake of union before they knew the terms of the compromise. That's an example of civic charity. The most fundamental impulse that created the Constitution of 1787 was the desire to create a union with those of different views. That, I believe, is a fundamental insight into the creation of the Constitution and to its survival. Michael Gerson writes, "The heroes of America are heroes of unity. Our Constitution is designed for vigorous disagreement. It is not designed for irreconcilable contempt." The Constitution itself was born in compromise. Both sides sought convergence where neither side sought total victory. Compromise looks for ways to accommodate the legitimate concerns of the other. We remember the words of Martin Luther King, who said, "Our purpose is not to defeat or humiliate the opponent, but to win his friendship and understanding." That's civic charity. That's how the Constitution was created. The most dominant theme of the Federalist Papers is a warning about the danger of extreme partisanship. 55 of the 85 Federalist Papers were concerned about partisanship. And perhaps the most influential of the papers, Madison's, number 10. He observed that extreme partisanship was the main reason republics failed in the past. So here's my pitch. That's all the wind up for this pitch. If you want to support and defend the Constitution, which all civil officers and military officers take an oath to do, all members of the bar take an oath to do, and hopefully all citizens of the United States have a desire to do, to support and defend the Constitution, here's the primary way you can do that. Commit to work for unity. Be an agent of reconciliation. Don't be an agent of division. And maybe when we get into question and answers, I can tell you some of my thoughts about how one becomes an agent of division as opposed to an agent of reconciliation. So let me finish with this. How does civic charity, this idea, work? You showed how it worked back in Philadelphia in 1787. How does it work today, particularly in the tug and the pull between religious liberty and equality? Both key values we want to protect and defend in our republic. I'm going to rely on the scholarship and the work of the former dean of Harvard Law School, a political progressive, Martha Minow. Dean Minow, for years, has written about the importance of compromise. That compromise in this area, in the tug and pull between religious liberty and equality, that compromise can allow the type of accommodation that she argues is actually indispensable for stability in a diverse society. She writes, attitudes of respect, flexibility, and humility can help generate new answers beyond exemption and no exemption when religious principles and civil rights collide. Dean Minow points out, humility involves restraint and making room for open and respectful exploration of the other point of view. She also points out that the most likely agents to reach such a compromise are not judges. It's not litigation. It's through the political actors, through politicians and government actors who can strike accommodations and compromise. I'm speaking at an event sponsored in Utah. I can't help but observe that's the home of the Utah Compromise. The Washington Post account of the Utah Compromise records that it was the result of meetings held in the homes of negotiators. Apparently, the negotiations started out in a law firm office around a conference table in a very Utah way. It went to the homes of the negotiators soon. And that setting helped, according to the Post, helped create enduring and emotional friendships. And these personal connections of trust and friendship were made across what had been thought to be an unbridgeable divide. In the words of George Washington, the Utah Compromise was the result of the spirit of amity and mutual deference, which the peculiarities of the political situation rendered indispensable. I believe we're in such a moment now. We are polarized as we have never been since the Civil War. It's hard work to forge compromise. It requires a self-awareness and a self-honesty that I realize that there are things that I have to give up. There are things that I have to give up to be able to live in unity with others who have different interests. Now, obviously, there's got to be some line. Can't give up everything, right? But I can probably give up a lot more than I thought I could for the sake of unity. That's the spirit of civic charity. That's hard work. But you know what? We can do hard things. Thank you.
Many thanks for both of those presentations. There's a lot to talk about. We have approximately 20 minutes for questions. These are coming into me via chat, so I will pose one to begin. One of our observers would like to know a little bit more about the Equality Act and specifically what provisions in the Equality Act have or present the most concern for religious freedom issues.
Judge, do you want to take that, or are you?
No, you're the expert there.
Yeah. Well, first of all, let me just say that that was just a terrific presentation by Judge Griffith. Really fantastic. We need you back on the bench. You shouldn't have retired. I think from the perspective of religious liberty, and I haven't read through the entire Equality Act, but as it's been reported, the House version has a explicit textual provision that says, as related to this act, I'm paraphrasing here, as related to this act, the Religious Freedom Restoration Act is basically inapplicable. So the Religious Freedom Restoration Act does not cover you as applied to the provisions of this act. The Equality Act, again, I'm relying on news accounts of this, also expands the notion of what a public accommodation is. So it encompasses more and more of what used to be the private sphere into its scope.
Brian, can I pitch in?
Please do.
So I finished with this note borrowing from Dean Minow. By the way, that's a trick that political conservatives always do, right? We quote our friends who are political progressives, but I do so with her permission. She understands. In fact, I just wrote her today saying, I'm doing it again, Martha. I'm going to quote you again. But I think the discussion of the Equality Act drives home a point she's trying to make and with which I agree. Look, there are times when you need to litigate, right? I mean, if your constitutional or statutory rights are being infringed and you haven't been able to have a redress of grievances through the political process, no, you go to the courts. But the courts just are not well equipped to handle these competing claims. And the political branches are. But here's the problem. The political branches right now are at each other's throats, right? And to me, that's the problem. You know, I don't do politics real well, but it seems to me there are plenty of deals that ought to be able to be struck here, right? Between the legitimate claims of the LGBTQ community, for example, and the legitimate claims of religious adherence. We ought to be able to come up with some sort of solution there. If both sides are willing to compromise because they genuinely want to live in a community with others. And see, that's the problem, right? We've got, and I'm not a sociologist, but increasingly we see people retreating to their own communities, intentional communities where they don't want to be with others. I think that's a problem. I think that's a danger.
Brian, can I raise a question here? More just to have a bit of a conversation with the judge. I'm curious to ask the judge. I mean, one compromise would be to actually increase the private sphere, live and let live. And we typically think, and I think the spirit of your comments was, well, exemptions are a way to compromise.
Mm-hmm.
I'm a little bit skeptical of that. Exemptions are a way to polarize in a way. Madison's scheme for compromising was basically no law should be passed unless the law can apply to everyone. And if you can't pass a law that everyone would be happy to be under, don't pass a law at all. And so an older way of compromising was sort of, I mean, this was religious. Let's not establish a religion. Let everyone, let's take religious establishments out of the government. Let's not establish a sexual morality. Let's just leave each other alone. That actually strikes me as the older understanding of compromise, to demand less of politics.
That could be a very fruitful line of inquiry. I'm using the exemption, no exemption, because that's what the courts have created, right? That's an example, I think, of judicial overreach here. But yeah, you're the political scientist. You come up with better ways than I could have. But the key is, to me, that I have to be willing to want to be in community with people who have very different views than I do, and that can't. I gotta be willing to do that, and vice versa, right? Now, whether you do it as a matter of exemption or in your sort of Madisonian view, I'm not. Both seem fine to me. Both seem fine to me.
Yeah, I don't know if it's really possible today, but I mean, one way to live in, be in community is actually live and let live.
Yeah.
And don't use the force of law to coerce anyone. Just leave people alone.
Now you're edging me into a libertarianism that I don't know.
We should get back to the regular.
Okay, no, that's good.
Great discussion. So for you, Judge Griffith, the questioner says, how do you feel civic charity would change or impact the conflict that exists in religious liberty claims, and especially at the level of the Supreme Court?
Well, this isn't something for the Supreme Court to do. The Supreme Court needs to construe the law and apply it, right? This claim for civic charity is more about the citizenry, right, and our elected representatives, what we want and demand and expect of our elected representatives. That's where that really comes into play. And I think where it works is you end up compromising. I have a certain set of interests that I think are vital, and I think civic charity suggests that, well, maybe I ought to be a little bit more introspective and say, you can't have everything, Tom. You can't have the world just the way you want it, because you live in a pluralistic, diverse society. Now, if you don't want the pluralistic, diverse society, this is going to sound harsh, well, you go buy a desert island somewhere, right? Or, but no, we live in a pluralistic, diverse society. We're committed to that. And that means to make it work, you've got to give up some stuff. Now it's got to be two sides. It's got to be two ways, right? It's got to be two ways. Both sides need to stop weaponizing their beliefs and look for ways to accommodate one another. That as I say that, and I give this talk a lot, it just sounds so naive at times, right? It just sounds so like, what world are you living in? But I take some comfort from the fact that there are a lot of people who are arguing this. This is just Arthur Brooks and David Brooks and others making this point from the center right, that we have to find ways to accommodate. I gave an early version of this talk a number of years ago, and in a very hostile environment, Yale Law School, and it was not well received for the following reason. I did not understand then that civility can be a code word for shut up, right? For marginalized groups to shut up. And so I want to stress that I don't think that's what I'm talking about. No, people need to speak up. People need to speak up. These are important issues. They're issues involving our own identity. It's just that when we speak up and the way we speak up, we can't do so out of contempt, right? And then the final point is, and you got to be prepared to compromise. You got to be prepared to compromise. If MAGA supporters can't imagine living in the same community as Bernie Sanders supporters, or vice versa, there's the problem. There's the problem. David Brooks says this, and I love this. He said, "I have never lost a friend over politics. They're not that important." Look, politics are important, but we can't use them in contempt. That's the point. Can't be contemptuous.
Well said. Dr. Munoz, do you have anything to add?
No. I mean, I think candidly, I should just be quiet and we should listen to Judge Griffith. This is terrific.
Not true at all. Not true at all. Okay, our next question comes in from Scott Paul, and it says, what are the 21st century equivalents to the 1787 dinner groups where the ideologically unaligned can grow in acquaintance? And Tom, you mentioned one example that we'd like to hear more on that if you would like to share.
Sure, I'll take a crack at that. And so now I'm going to take a long bow and aim it at my fellow citizens. Okay, here is a problem. It may not realize this. This may be sort of an example of unintended consequences. Congress can't vote themselves a pay raise, right? What happens when Congress votes themselves a pay raise? They get primaried, they get challenged. People back home saying, "Oh, they're elite," so they don't do it. So as a result of that, most congressmen cannot afford to live in the Washington, D.C. area. Because if they sell their home back in Indiana and buy a place in Washington, they've gone native, right? And they get primaried. So the result of it, I grew up in the suburbs of Washington, D.C. My parents were government workers. We were fine, we weren't wealthy, but I went to school, to public schools, with the sons and daughters of congressmen and senators and Supreme Court justices. We weren't special. That was just that's the way things were. Go to a Little League game, there's a Supreme Court justice there, right? Go to PTA, there's a congressman there. Now, the point is, they got to know each other. Congressmen and senators got to know each other then. And it's, once you get to know somebody, typically, it's really hard to hate them. And sometimes it's not, but it's hard to hate them. But right now, the typical congressman or senator flies in to Washington Tuesday morning. They do their business Tuesday, Wednesday, Thursday, and then they fly out Thursday because they got to go back home, because if they don't go back home, they're going to get primaried. They can't afford to live in DC. So they live in these awful these terrible places. At one point, I've forgotten the number, but I think at one point it was like 30 or 40% of the members of the House of Representatives live in their office, and shower in the House. This is absurd. They don't know each other. I heard Senator Chris Coons once say at a lunch with the judges on my court that the only time he gets to interact with people across the aisle is at Bible study on the Senate Bible study on Wednesday, and then running into them at the gym. The point is, they don't know each other, and it's easy to go on Fox News or MSNBC and say horrible things about others. I've taken too long with that, but that's what there are proposals to build a dormitory on Capitol. Not going to go anywhere. Build a dormitory on Capitol Hill, and you got to live there and get to know each other. That's not going to happen, but it underscores the point, at least at Congress.
Can I just add something here? One thought. The 21st century equivalent of the 1789 dinner party is certainly not Twitter or any social media. maybe one of the equivalents, or I mean, first of all, just the dinner party. that's just inviting people in your homes, actually talking to neighbors, people you disagree with. But one place where we actually are supposed to do this is on our college campuses. And I'm really troubled. There's even here at Notre Dame, a trend where there are sort of, if you're a political liberal, you take these sorts of courses, and a political conservative, you take these sorts of courses. And that's just terrible. We need to have small seminars with students who disagree, have robust discussion and debate. The best thing that ever happened to me when I was in college, my sophomore year, my roommate was a committed Marxist. And I thought he had crazy ideas, but he was a great guy. And we stayed up very late talking. I had in college friends all across the political spectrum, and they're still very good friends today. And I don't think that's so true for young people now, that they group by political affiliation in their friendships. And I suppose I can understand why that happens, but it's, I think, really unfortunate. Because exactly what the judge said, it's you can disagree with someone. In fact, you can have the best disagreements with your friends, but there's got to be that underlying friendship. And that civic friendship is desperately needed today. And the place we can teach it is actually college campuses.
Amen. Yeah, what's happening in higher education on the free speech front is stunning and shocking to someone who came of age in the 60s or 70s. This is the opposite of what was supposed to happen. So couldn't agree more.
So for Dr. Munoz, we had a question come in about the recent activities regarding the Satanic Temple cases and what their implications might be for religious liberty as it relates to non-Christian groups.
I want to say I plead the fifth. No, I don't. I'm unfamiliar with the Satanic Temple events. So, Judge, do you know, or Brian, do you know? I just don't. I'm not aware of.
I just know headlines, and that's about it.
Yeah. I'm sorry. I should know about these things. I just don't.
Well, then we'll pass. I'm interested to know. I mean, and we're running out of time. Kind of as this session is titled, looking ahead to the future. Where do you see the country 10 years from now? Specifically with you, Dr. Munoz, where do you see it in terms of religious freedom issues, legal issues? And Tom, where do you see it in terms of civic charity that you invoked?
Boy, that's a big question. And I mean, the judge started off his comments on a note of pessimism. And unfortunately, I'm pretty pessimistic. Let me not end that way. I have great faith in the American people, actually. I think most Americans in the heartland, on the coast, most Americans are actually very sensible, and they have a live and let live attitude. If they're religious or not religious, they're relatively respectful of religious freedom. I think our elites on both sides are the most polarized. And so I guess, I'll cast my lot with the American people. I had hopes that President Biden would be the moderate figure that he presented himself to be during that campaign. And I still have hopes he'll move that way. He hasn't really been governed as a moderate, but maybe he will. I think that's kind of where he is as a person. So that's maybe naive or unduly optimistic, but the more we just let the American people govern themselves, the better off we'll be. And so I'm, to the extent that one can be hopeful, it's really not in our elites. It's with everyday Joe and Jane American that I still think are full of common sense.
Well, I hope you're right. I mean, hope is a choice, and I'm going to make it, but I'm not optimistic. Although what's the famous quote attributed to Yogi Berra, right? So probably never said it, but I'm not very good at predictions, especially about the future, you know. So, but I'll make one here. I am pretty optimistic that this Supreme Court cares, it understands religious liberty and cares about it. And it's not just the, not just the typical conservative versus liberal bent. I think almost all the justices have some sense of the importance of religious liberty. So I'm actually pretty optimistic about that. On the larger issue of American culture, I'm less optimistic. The discussion is just so toxic. Now, maybe Professor Munoz is right, though. I think only 6 or 7 million people watch cable, right? But that's the problem. There's the problem, right? And so I'll end with this exhortation. Sorry, Kiana, I'm going over time. In the penalty period, if your primary source of information is from social media, or particularly cable, you're being played. Particularly if it's cable, you're being played. I mean, no, there are algorithms that figure out how to get you to watch. And Arthur Brooks calls this the outrage industrial complex. They know that if they create a sense of outrage, you'll watch, and that's cable's business model. So if you're buying into that, you're being played. The bad news is, to stay informed, you have to read, and it takes a long time. It's not easy. Citizenship's not an easy thing. So I guess, Brian, I'm not particularly hopeful, because that's really hard work, and it seems that most of the political leaders, most of the dynamism is towards polarization and misinformation, and we're living in when 75% of Republicans believe the election was stolen. 44% of people in Utah believe that. Those are damning statistics that hopefully we can remedy, but I'm not too terribly optimistic unless we draw upon the history of civic charity and let that form our political allegiances and views. Way over time. Sorry about that.
Thank you. Dr. Munoz, anything you'd like to add before we close?
Oh, not at all. Just thank you to UVU, the Program on Constitutional Studies. Really, these conversations are really important. So thank you very much for your leadership on this.
Well, many thanks to both of you. And again, as we close out this event, I just want to personally thank my colleagues and friends at the Center for Constitutional Studies for their hard work, their interest in cultivating dialogue across difference. And I look forward to working with them here at UVU. And as we move forward, look forward to seeing many of you who are watching here today, hopefully in person, so that we can regain that human contact that many of us long for. So with that, we'll turn it back over to Kiana.
Thank you. What an informing and inspiring session, and what an outstanding finale to our conference. I express sincere appreciation to our outstanding speakers and moderator. I invite them to join the post-session breakout room at this time. This concludes our conference. We hope you have enjoyed the proceedings. Scott Paul, our interim director and executive director of the UVU Center for Constitutional Studies, will offer a few concluding remarks.
Thank you, Kiana. And again, thank you to the outstanding speakers and moderators who have joined us for this session and throughout the conference. We've been well informed. We've been well informed. We've heard compelling cases for various religious liberty perspectives, and hopefully we've developed new insights and enhanced our own perspectives. As we close this conference, I must thank Carrie Dennis, our events and marketing manager. Carrie and her team have seen to all the publicity and logistics for this conference, and they're the ones producing the online sessions. So thank you to them. Finally, I invite you to join us again for future events here at the Center for Constitutional Studies. You can learn about our events at our website, uvu.edu/CCS, or by following our social media accounts at CCSUVU and at CCS for Students. That second account is specifically targeted at undergraduate and high school students. Again, thank you for being with us, and we look forward to being with you again.